please. So I'm supposed to have IT show up when things aren't working. So tell me what's not working right now.
This may be our internal thing.
Okay, I don't want to drag them into that.
The actual, it's the normal stuff. I tried to play it on Zoom this morning and it's the normal.
Okay.
Lag, but that's.
No, but they should come watch it because I am told, well, we don't ever see it. How do we know it happened? Hmm?
Yeah, he reminded me.
Oh, right.
It should be a thing, I forget, but now I don't know why.
She can finish this time. No, she was needed. I don't. I think she was just taking. So I went for that. We can blather, that's all. The stand that you want to.
So, Mr. Body, you tried this morning playing it on the regular approach and it did the usual thing.
Yes.
Okay, so want to make sure when I send this email. All right, Ms. Rivers, are you ready? Let's get on the record in State versus Dennis. We have Mr. Dennis here. Good morning, sir. With his lawyer, Mr. Bass. Our prosecutors are here. Our jurors are here. Do we have state's witnesses ready to go? Do you need a minute to get the technology ready?
Like maybe like 3 minutes.
Okay,
I object to 3 minutes.
I'll make it 5 then.
Okay. And knowing you the whole time you've already called.
Yes.
Yeah.
We good? Good enough?
It'll work.
Okay. All right, let's get the jurors, please.
All right, let's do it. I'll do the president of the town board.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, jurors. Happy Thursday. Great to have you back here on time and ready to go. We will continue with and hopefully wrap up the state's case this morning or early afternoon. When you are ready, Mr. Rao or Mr. Abadi, for your next witness.
Paul's Martin Gravely.
President, raise your right hand. Will you swear affirm that the testimony you will give will be true, the whole truth, and nothing but the truth, so help you God? I do. Do it on my seat. Can you say, spell your name for the record?
My name is Martin Gravely, MartinGravely, and I'm the third. I'm good. How are you?
Great. Would you mind telling the jurors where you're currently employed and work for a living?
I'm employed at the Georgia Bureau of Investigation. I am a firearms examiner with them.
And how long have you been employed with the GBI as a firearms examiner?
Approximately 2 years, excuse me. I'm sorry.
And prior to that, were you working in the same field at a different location, or has this been where you've primarily worked as a firearms examiner?
I have worked at the GBI prior to becoming a firearms examiner. I started there in 22 as a laboratory technician. I was then promoted from laboratory technician to firearms examiner in April of 23, where I then began a approximately 2-year-long or 17 months to 2-year-long training program, which included about 15 months of hands-on learning where I was taught the history of firearms. I was taught comparison microscopy using a comparison microscope, where I was able to examine 2 different fired ammunition components, bullets and cartridge cases, underneath a I was taught how to look and able to determine that 2 bullets were fired from the same firearm, as well as 2 cartridge cases were fired from the same firearm. I was taught how to restore serial numbers that had been obliterated, and at the end of each of those blocks of training, I was given a written test or a practical test or a oral exam or a combination of the 3, and I had to pass each one of those before I can move on to the next thing. And then I had approximately 7 months to a year-long supervised casework where I would work cases under the direct supervision of another fully trained examiner who would fully rework my cases and give me feedback where it was needed.
And in the GBI, when ever a firearms examiner tests a piece of firearms evidence and generates a report, is that typically peer reviewed and verified prior to the publication of that report?
Yes, all of our reports are verified and peer reviewed.
That's 2 steps, not just a verification and peer review. They're not the same things.
That's correct. When I, as the primary examiner, finish my examination, I will then give the fired ammunition components as well as the firearm evidence to another fully trained examiner. That will be the verifying examiner or the secondary examiner. They will then do their own comparison to come to their own conclusions, and provided that we come to the same conclusion, it will then go forward into a peer review step. And the peer review step is where a third fully trained examiner will review all aspects of the case to ensure that all GBI, Division of Forensic Science, DOFS policies were followed. And then after it goes through all of those steps, then the case is released to the public or published, as you say.
And in your time with the GBI as a firearms examiner, have you ever had to testify in court as an expert witness in the field of firearms examination?
I have.
And does that include for both the prosecution and the defense?
It is.
Your Honor, at this time, the state would seek to admit Mr. Gravely as an expert in the field of firearms analysis.
Mr. Bass, any objection or any voir dire?
Like you. Your training includes the identification of various firearms, correct?
The fired ammunition components, yes, such as cartridge cases and bullets.
You can tell what types of weapons, handguns or rifles can fire what types of ammunition?
Typically speaking, if it's a rifle cartridge, it's going to be longer or larger. Cartridge case and bullet. The bullet itself may be smaller than what a pistol cartridge would be, or pistol bullet would be. I have a demonstrative if it would be easier to explain.
Sure, when?
Okay. So this is an example of a cartridge. This is a pistol, an example of a pistol cartridge. This is the bullet, and this is the cartridge case. Typically speaking, for a pistol cartridge, it's going to be looking very similar to this. It may be longer, it may be shorter, maybe fatter, and all these different things. But typically with rifle caliber cartridges, it'll have a neck where it kind of comes down and encases the bullet, and then the cartridge case itself will expand. So through those ways of the manufacturing of the cartridge, I'm able to determine if it is more of a rifle caliber or a pistol cartridge or caliber.
And you use the word typically throughout your testimony regarding the demonstrative evidence that you produced, correct?
Yes.
Typically necessarily does not mean all the time, correct?
That is correct.
Judge, I think in terms of voir dire, just going beyond the scope of that, these are questions I normally would get into after the qualification of him being an expert witness.
And Mr. Bass can as well. So let's focus on qualifications, and then you'll have a full opportunity to cross-examine if you wish to.
I'll accept the offer and stipulate that he's an expert and yield the witness back to you, prosecutor.
All right. So, Mr. Gravely, you are, for the purposes of this trial, qualified as an expert in the field of firearms examination.
Gravely, when generally speaking, are you able to determine what type of firearm was used when when you are examining a projectile?
Yes, typically. So I'm going to start from the very beginning, like I was with the cartridge. So as I said, this is a cartridge, this is a bullet, this is a cartridge case. Inside of the cartridge, it has a primer and it has gunpowder. So when a firearm, or when the trigger on a firearm is pulled, it is going to release a firing pin or a hammer. It's going to strike the primer. When it strikes the primer, it's going to cause a spark that ignites the gunpowder within, it's going to cause rapid gas expansion, pushing the bullet down the barrel of the firearm. Equal and opposite reaction, when this is going this way because of the gas pressure, it causes a seal, causing the cartridge case to be pushed back against the breech face, like this. It's going to pick up characteristics from the breech face, the ejector, and the extractor, and the firing pin, multiple things, as well as when the bullet is traveling down the barrel, it's also going to be picking up the rifling of that barrel. Now, rifling, as you can see, there are cut grooves here. Rifling in the barrel of a firearm are cut or impressed lands and grooves that impart a kind of spin on it because there's a twist to the rifling. And so when a firearms manufacturer creates the firearm, they have a design in mind. And so they want their lands and grooves to be maybe 0.13 inches in width and 0.78 inches in width. These are all class characteristics that I am able to view and measure that I will then put into a database called a GRC, which stands for General Rifling Characteristics. And through that database, I will be able to determine if several different possible manufacturers for that bullet. Similarly, with the cartridge case, I will look at other class characteristics such as the firing pin shape, the extractor location, as well as the ejector location, and breech face marks to then put into a in-house database ran by the GBI. And it will give us other possible firearms that could have fired the cartridge case. So through that, I'm able to determine what manufacturers may have fired the bullet or cartridge case.
In an instance where you are, or your colleagues are provided, say for instance, a number of projectiles, are there mechanisms for you to determine whether those projectiles were fired from the same firearm or different firearms without having the firearm itself that ejected those projectiles?
Yes. The way we are able to determine if two projectiles or cartridge cases were fired from the same firearm is a process called light comparison microscopy. So that takes, it essentially is a comparison microscope, which is similar to that of a compound microscope that you may have seen in high school in biology class maybe. The only difference is it has two stages where you can view two different objects. It is then connected through an optical bridge that allows me to see two objects under the same magnification at approximately the same light. And through that, I'm able to view the class characteristics that gives me a general idea that maybe these were fired from the same firearm. And then I go into the individual characteristics. So as the bullet goes down the barrel of the firearm, it picks up these tiny little imperfections from the barrel that happened during the manufacturing process, and it's imparted to the bullet that is left behind. And so let's say these two bullets were possibly fired from the same firearm. I am then able to look at them both under my comparison microscope and then spin it until I see that, hey, this area right here looks good. And if it lines up perfectly, near perfectly, I'm able to determine that it is that they were fired from the same firearm.
So from the rifling impressions that are put on the projectile as the projectile is being fired from the gun, the individual characteristics that you previously testified to that are left on the projectile, are those unique to not just a brand of firearms, but to a specific firearm?
Yes. Yeah, those imperfections are unique to that individual firearm, yes.
That's sort of like fingerprints, no two fingerprints are alike?
You can use that, yes. You can say that, yes.
So with respect to, having a particular firearm, are you able to match, whether or not projectiles that you received were in fact fired from the specific gun that you're testing, or at least rule it out?
If we receive a firearm, we will observe the class characteristics. So for example, if let's say a bullet has a 6 right, meaning it has 6 impressions or 6 lands or 6 groove impressions, and it twists to the right, and the firearm itself has a 5 left twist, I can determine, not even looking at my comparison microscope, that it was not fired from that firearm. If, let's say, the bullets have 6 right and the gun has 6 right, I will then go into the next stage of my firearm examination. I will test fire that firearm. I will try and get as close to of the ammunition manufacturer that I actually can, and then I will go and I will create test fires so that I am able to examine the evidence to the test fires of that firearm to determine if the evidence and the test fires were fired from the same firearm. If they were, again, like I said with a comparison microscope, I'll look at them both underneath the comparison microscope and I will determine if the individual characteristics line up.
Now, as it relates to handguns and specific types of handguns, can you explain to the jury what the difference is between a semi-automatic handgun and a revolver in terms of when they fire a projectile and eject a shell casing or lack thereof?
So a revolver is is a type of handgun. It is designed. The definition of a handgun is a firearm that is designed to be fired with one hand. Typically, people will hold it with 2 hands just to stabilize it. However, it can be shot with one hand. A revolver has a cylinder that has anywhere from, I've seen 5 up to, I think, 12 chambers within a revolving cylinder. So the shooter will put the cartridges into the cylinder, and then it will rotate along a central axis to become in line with the barrel. From there, the shooter will then pull the trigger, detonating the primer, causing the bullet to leave the cartridge and travel down the barrel to wherever. The important thing, the important distinction between the revolver and the semi-automatic pistol, which I'll get into in a moment, is the cartridge case in the revolver stays in the revolver. As you can see, do you mind if I stand really quick?
For the record, I'm showing the demonstrative that was provided to Ms. Stevens through Mr. Gravely as well. So the cartridge case will stay within the cylinder here.
Now, with a semi-automatic pistol, to feed a cartridge into that firearm, you will place it into a magazine, or you can manually place it into the chamber. And let's say you put it in the magazine, you will insert the magazine and you will rack the slide, which means moving the slide, which is here. You will pull it rearward and then let it go forward, and it's going to strip a cartridge from the magazine and placing it into the chamber, where then when the shooter pulls the trigger, it's going to detonate the primer, cause the bullet to leave and go down the barrel. Importantly, when I said that it hits the breech face, it also pushes that slide rearward with an extractor here, causing it to come back, hit what is called an ejector, and then kick the cartridge case out. So that is the primary distinction between a semi-automatic pistol and a revolver, is the cartridge case either stays in the firearm with the revolver or is kicked out with the semi-automatic pistol. And importantly, when it kicks it out, the slide comes rearward and then it goes back forward to strip another cartridge and put it into the chamber ready for another trigger pull.
So with respect to the revolver that you've been testifying about, if a revolver was discharged, a projectile was fired from the revolver, a shell casing would not just come out of the chamber or barrel.
I would not expect it to come out unless the shooter manually removed it.
So if the shooter did not manually remove it or manipulate the chamber in any way, shape, or form, the shell casing would not emanate from, or would not eject from the firearm the same as it would from a semi-automatic.
That is correct.
Now, with respect to a 38 projectile, 38 caliber projectile, what is the significance of that as it relates to whether or not it can be fired from a semi-automatic firearm or a revolver?
So the distinction between a 38 bullet and a 38 class bullet is a 38 bullet is a distinction of specifically 357 Magnum bullets and 38 special bullets. They have the exact same class characteristics in the sense they have the same cartridge bearing surface length, which is this part right here, the part that interacts with the breech face. So they're going to have the exact same length. They will have the same exact ogive, which is the part right here, the nose of the bullet. It'll have everything the exact same. So in that sense, I am unable to determine if it was fired from, let's say, a 357 Magnum revolver or a 38 special revolver. In contrast, a 38 class bullet is different from a 38 bullet because has a shorter bearing surface length. It is similar to what is a 9mm bullet, a 380 auto bullet, a 9mm Makarov bullet. All of those share other characteristics that lead them into their own group. So in this situation, a 38 bullet is typically a 38 bullet is fired from a 357 Magnum or a 38 Special, and a 38 class bullet is fired from generally a semi-automatic pistol.
The distinction between a 38 class and a 38 bullet, is that correct?
Yes.
And with respect to the 38 bullet, you previously testified that can only be fired from a 38 special or a 357 Magnum.
I would expect it to only be fired from a 357 Magnum or a 38 Special, yes.
Are those revolvers?
Correct.
I'm turning your attention to DOS number 2024-1004459. Are you familiar with that case number?
I am, yes.
And when you and your colleagues are assigned to cases, is there typically a case number that's generated within the GBI just for classification purposes?
There is. So when an agency delivers evidence to the GBI, whether it be through physically coming in and giving it to us, or through giving it or putting it through our lockbox system, or through the mail, it will be received by our evidence receiving section, who take the evidence and they give it a unique barcode, a DOFS or Division of Forensic Science barcode. In this case, it was given the distinction 2024-1004459, and then that barcode is able to be scanned throughout the GBI so that we're able to maintain a chain of custody so that we know who has it, where it's at, and all this to the time.
And were you asked to test 238 bullets with respect to that particular case number?
I was.
And were you able to generate conclusions that were peer reviewed and verified and author a report that you published?
I was.
I'm going to approach you with what's been pre-marked for identification purposes as State's Exhibit 64. Gravely, as it relates to State's Exhibit 64, is this the report that you generated as it relates to specifically the analysis that you performed on the 38 projectiles?
As it relates to the projectiles, yes, this is my report.
Is that a true and correct copy of the report that you generated specifically as it relates to your analysis on the 38 projectiles? Or 38 bullets?
Yes, yes it is.
Your Honor, at this time, the state would seek to admit State 64 as evidence.
No objection.
64 is admitted.
I'm going to approach you with what's already been admitted into evidence, State's Exhibit 61. Mr. Brady, do you recognize State 61?
I do.
How do you recognize it?
I recognize it through the Division of Forensic Science barcode. As you can see, it has the barcode that we're able to scan. It has the number right here, 2024-1004459. I also am able to determine it because it has my initials on the blue evidence tape up here. as well as on the items itself, I have my initials on it as well.
And so those would be the projectiles that you analyze as it relates to the report in State's Exhibit 64, is that correct?
That is correct.
And what were your conclusions?
My conclusions that were that both of the items were fired from the same firearm.
That they were 38 projectiles?
That they were 38 bullets, yes.
And do you have a list of firearms that it could possibly have been fired from?
I do.
What is the list that you generated out of your report?
The list was that these bullets were consistent with being fired from a Rossi 357 Magnum revolver or revolvers, and Astra, Rossi, Ruger, and Taurus 38 special revolvers.
All revolvers. Is that correct? That you were able to generate from your report?
A number of revolvers, yes. There are many, many revolvers out in the world. I was able to determine it was from these, but it's not an all-inclusive list.
Thank you. I have no further questions.
Mr. Bass, questions for Mr. Gravely?
Yes. In your preparation for coming today, in your discussions with prosecutors, detectives, medical examiners, whoever you spoke with, are you under the impression that this is not a what done it, this is a who done it?
I'm gonna object to lack of foundation, speculation.
You're testifying about I'll rephrase.
Okay, let's try it differently.
380 caliber slug.
I'm testifying to a 38 bullet, not a 380 slug.
380 caliber bullet.
No. Say again what you're testifying about?
A 38 bullet. A 38 bullet, not 380.
380 stuck in my brain.
Okay.
All right, so you don't know what gun fired the bullet.
I was not given a firearm, no.
You don't know who was holding the gun that fired the bullet.
That is correct.
You don't know where the person was standing, physically located when the bullet was fired.
That is correct.
You don't know where the person, if a person was struck, would have been standing vis-a-vis the person who pulled the trigger, correct?
I know a person was struck via when it was received by the medical examiners. It has on the box that it was recovered by a person. However, you're correct. I do not know where that person was.
You don't know who was around the shooter if somebody else was present.
That is correct.
You don't know the circumstances surrounding the shooting that led to you doing your analysis.
That is correct.
Your list that includes Rossi, Astra, Ruger, Taurus, it doesn't mention Charter Arms, does it?
No, it's not an all-inclusive list.
Doesn't mention Smith and Wesson either.
That is correct.
If something like Smith and Wesson's not on your list, does that mean you were able to tell from the lands and grooves, or whatever we call them, that it wouldn't have been a Smith and Wesson? Or are you telling us that your list is what I call an EG? For example, these bullets could have been fired from, and you list these guns, but all these others that Mr. Bass is mentioning also could have been the make of revolver that fired the 38 rounds.
So it was not. It could have been a Smith and Wesson. However, Smith and Wesson revolvers typically have a 5 right rifling structure, whereas the bullets that were recovered here had a 6 right rifling structure. So it's very unlikely to be a Smith and Wesson. The list that I was able to generate is ran. Like I said, it's called a GRC. It's ran through AFTI, which is the Association of Firearm and Tool Market Examiner. It is a list that they maintain. It is kept up to date. At the time that there's a version number on my GRC list. I'm not sure the last time it was updated. However, it has a long list of possible firearms that could have fired it. On there, I did not see Smith and Wesson on there.
Where is the longer list that you did not bring to court today?
I have the list right here in my notes.
Includes everything?
It has all of them that were provided on the day that I generated the,
Is that list longer than the list you just read off to the jury when questioned by the prosecutor?
yes, because it's not an all-inclusive list that I reported on.
So on the longer list that you didn't mention, it's not all inclusive, but why not read the longer list? Why did you choose to read a subsection of a longer list to this jury?
Because at the end, it's not an all-inclusive list either way. And so I chose the ones that I see most likely and what I see most often in casework.
You got a list of guns that could have fired what you analyzed, and you chose to tell us about a smaller subsection of that possible group, correct?
If you would like, I can offer you the full
I'd
list.
like you to answer my question.
I distilled it down to the firearms that I typically will see, yes.
Does that include handguns that were modified by the owner post-purchase?
I don't know. I can only tell you the firearms that are submitted by the manufacturer themselves. What the owner does post-purchase, I cannot speak to.
Is it common practice in the gun community for people who own guns to have their guns customized? Change the triggers, get new barrels, get new handles, grips, and the like?
It's sometimes people will do it to customize their own experience. Sometimes people want a lighter trigger pull, so they will get different triggers. Yes, it's common.
Would changing out the trigger affect the rifling that you would see or the lands and grooves on the rounds?
No, it would not.
Can change the barrel of certain handguns, correct?
Certain handguns, yes.
The caliber of bullet that you analyze would be considered a larger caliber bullet, correct?
That is, what do you mean by larger caliber? In reference to like a 22 or a 40, like, what do you mean by that?
Most experts would understand that a large caliber bullet would include bullets of a certain weight.
So why don't you ask your question instead of telling him what most experts would do?
Do you discuss firearm analysis on a regular basis with other firearms experts?
I do discuss firearm examination with my colleagues, yes.
Do the other colleagues you discuss with, the other firearms expert, refer to this caliber of bullet being a large caliber bullet?
For a 38 bullet, this is very typical of a weight for a 38 bullet. In comparison, I've seen some bullets that are 500 grains, but they were also fired from an air rifle with no rifling.
I wasn't referring to the grainage of the bullet. I was referring to the caliber. A 22, a 9mm would not be considered in the same weight classification that the bullet that you analyzed would be found in, correct?
That is correct. 22s are smaller. They will generally be about anywhere from, I've seen some that are about 40 grains to about 55 grains. Grains, by the way, is a weight that is used for bullets. About 5,000 grains is 1 pound, although it's been a long time since I've done that conversion. But for this weight, it was approximately 158 grains, which is very typical for 38 bullets.
Speaking as to the weight of the bullet, the classification, is it typically the case that as the caliber increases, necessarily to make the weapon operable, the weapon has to become larger to accommodate the different processes occurring at the time of the trigger pull?
Not necessarily. There are 22 long rifle and there are 22 cartridges that can be fired from a rifle, which is a firearm that is meant to be pressed against the shoulder and held with two hands. And there are also 22 handguns and revolvers that also shoot 22 long rifle. So just because the caliber is small or the caliber is large does not necessarily mean that the firearm has to be small or large.
You used the word typically in the beginning of your presentation quite often. You remember that?
Yes.
I'm using the word typically now for the next group of my questions. Typically is the size of the handgun going to increase as the caliber increases?
It can.
If you knew that a gun was small and that's all you knew, would you tend to expect, as an expert in firearms, as you are, knowing the gun is small and that's the only thing you know, would you expect the gun to be of a smaller caliber?
Speculating, yes. Yes, it typically, if the handgun is smaller, typically the caliber will also be smaller, yes.
The photographs that you were shown by the prosecutor on the board, the semi-automatic and the revolver, both of those were full-size weapons, correct?
They appeared to be. I would not be able to tell just by a photo because the photo could be enlarged, it could have been shrunken. If I myself cannot see the model of the firearm, if I cannot see the caliber of the firearm, there's not much I can tell, aside from telling you that it's a revolver or a pistol.
I'm a little confused. Do you believe they were full-size or you don't know?
I cannot be sure, so I don't know.
You know if they're connected to this case at all?
The two firearms that were on the pictures,
Correct.
I am not sure.
Do you know what firearm is connected to this case at all?
I do not. I was able to determine a list, but I did not receive the firearm that fired those two bullets.
Are you being precise when you said you're able to determine a list?
So we've covered the list. Next topic.
The list you provided to the jury is not complete, correct?
It is a not all-inclusive list.
Right, so that's like the third or fourth time we've heard that.
And the
Anything
last.
else? Okay. Mr. Rao?
The photograph that I showed you, was that simply a demonstrative to explain the difference between what a semi-automatic firearm is and what a revolver is?
It would appear that it was, yes.
And that's what you testified to as it relates to the picture, is that correct?
That is correct. I was able to show that the revolver has a cylinder and that the cartridge case will typically remain in the cylinder versus the semi-automatic. It was demonstrative, yes.
It relates to a 38 bullet. The types of revolvers, let's go to the list first, okay? The list that you generated, both the one that you generated in the report as well as the exhaustive list, yet not all-inclusive list. Were they all revolvers?
Most of them were, yes.
And the ones that are most likely to have fired the 38 bullet, were those revolvers in your report?
Yes, they were.
And that's based off the rifling in
Leading objection.
was that based off the rifling in rifling impressions that were left on the bullet?
It was based, I was able to generate the report by getting the number of lands and grooves, in this case 6, and the twist right. I was also able to measure the lengths of the land and groove impressions, and then through that, I would put it into the database, and then it gave me the list. I also narrowed the list to include 357 Magnum and 38 Special because these are 38 bullets.
And 38 specials, firearms, 38 special revolvers or 357 magnums, are they Do they come in a wide variety of sizes in terms of the specific handguns that could have fired a projectile?
Yes.
That includes small. or large?
Objection leading,
Would that include small or large?
It could, yes.
I have no further questions.
nothing
Mr.
further.
Okay, questions from the jurors? Thank you. So, Mr. Gravely, you mentioned in one of your responses to the various lists we've been discussing that not all of the guns on, it sounds like it was the longer list from which you drew the list on your report, not all of them were revolvers. Could you share with the jury your estimate of the percentage of the guns that could generate the lands and grooves you identified were not revolvers?
May I look at the list?
Please.
With a quick approximation, I would say probably 60 to 70% of them were revolvers. The rest of them were Derringers. There was what appears to be one pistol and one that I'm not familiar with, RL. I believe that is a rifle of some sort. It is there are different acronyms of firearm type. PR stands for revolver. PI stands for semi-automatic pistol. PD stands for Derringer. So, but most of them are PR.
What's a Derringer?
A Derringer is a type of handgun. It's a very small handgun that generally will have 2 or more barrels. With one pull of the trigger, it will fire generally the top barrel first, and then if with another trigger pull, it'll shoot the second one. The cartridge cases will stay within the Derringer, though, until it is manually ejected. It is typically a break open type of pistol.
So a Derringer, in terms of shell casings, is like a revolver. The operator of the weapon has to manually remove the shell casings after the bullet's been fired.
In that sense, yes. Whereas the Derringer has multiple barrels, the revolver has one with a revolving cylinder. Yes.
Got it. When you described these revolvers as coming in all shapes and sizes, are there revolvers that are small enough that they can be concealed carried that would fire a 38 round?
Yes. Yes, there are.
And in your experience, how short can barrels be on small revolvers that could fire a 38?
Your Honor, I'd like to make an objection outside the presence of the jury, please.
We can talk about that later. I'm asking this question.
I have seen some snub-nosed barrels. I'm not sure exactly of the actual length of the barrels, but I do know that they can be fairly short.
But from your expertise, I understand you're estimating, does snub nose mean it's an 8-inch barrel as opposed to a 20-inch barrel on a non-snub nose, or is it half an inch as opposed to 3 inches?
Typically, a barrel will be anywhere from about maybe 6 inches, and a snub nose would be probably about 4 inches, about.
Right. Mr. Rao, do you have any follow-up questions?
No.
Mr. Bass?
What percentage of the weapon in common manufacture in the United States could have fired the 38 that you analyzed and are not revolvers?
Can you,
How many non-revolvers commonly sold in the United States in 2024 of last year could have fired that slug?
I'm not sure. You're saying how many non-revolvers could have fired these bullets?
Correct.
None, not that I'm aware of. There was one pistol on my list, but again, it's a non-all-inclusive list. So per my experience and what I've observed, I have never seen a 38 bullet travel through a pistol barrel. I've only ever seen them go through revolver barrels. That's not to necessarily say that it couldn't happen. However, in my experience, I've only ever seen these types of projectiles go through revolver barrels.
And how many revolvers in common production available in the United States? Not a niche purchase from overseas in Germany, but in the United States. How many could have produced above and beyond your list? How many more?
I am not entirely sure. It's a not all-inclusive list. It just gives manufacturers that were submitted to the AFTI glossary or AFTI forum, excuse me. It is what the members are able to give, and it is what is put back into that GRC. So there are firearms manufactured every day from a number of manufacturers. I don't know how many firearms could have fired these bullets, but I know that one firearm did.
The list that you spoke about receiving, do you know how that list was compiled?
I compiled the list. Are you talking about the before I input the values, or?
You received something in response to your inquiry, correct?
Yes.
Okay. The response that you received in response to your inquiry, do you know if that, before it got to you, even that did not include certain viable options?
I cannot speak to what was provided before I put my values in. It is a list, it was a database that is, that everyone around or all firearms examiners around the world can give information into. So it could have left out few things, but I have no way of knowing. The only thing I can do is put my values in and get the list back out.
Thank you.
Mr. Gravely, thank you for your time.
Thank you.
If you would gather up what's yours and leave on the desk what's not yours.
Will do.
Thank you. And while you're doing that, Mr. Bass and Mr. Rao, if you'll come with me, we're going to step outside.
Am I released?
You are. Thank you so much.
Thank you.
Yes, sir. All right, our next witness, please.
Second call, Detective Stansel.
Raise your right hand. You swear affirm that the testimony you give is the truth, the whole truth, and nothing but the truth, so help you God. You Lord, I see. Can you state and explain the name for the record?
Detective Sherrod Stansel, Sherrod, Stansel, Stancil.
Good morning, Detective Stansel.
Good morning.
Can you tell the jurors how you are currently employed, sir?
I'm currently employed with the City of Atlanta Police Department.
And how long have you worked with the City of Atlanta Police Department?
I believe 9 years.
And within your 9 years with the City of Atlanta Police Department, can you tell the jurors back in February of 2024, were you assigned to any specific unit?
Yes, sir. At the time of February 2024, I was assigned to the Atlanta Police Department Homicide Unit.
And currently, where are you assigned?
Currently, I'm assigned to the Atlanta Police Department Fugitive Unit.
And can you tell the jurors a little bit about, I guess, your responsibilities and duties as assigned as a lead detective in the homicide unit?
No problem. So being a lead detective on the homicide unit, essentially you are responding to the scene, whether it be from work or from home. In this particular case, I believe I was at the house. Oftentimes you'll get there, other detectives will be on scene, and it's information gathering, information sharing, trying to obtain information from others, trying to figure out some things, put pieces of the puzzle together. At the time that you do arrive, you do become a lead. The scene kind of belongs to you, and kind of everything is done at your direction.
I think you talk faster than any one of us. So
I apologize.
for Ms. Rivers' sake. Now, can you explain to the jurors, how does one become or get assigned as the lead detective?
So we use a rotation. I'm not sure how many detectives were assigned at the time, but within the rotation, it becomes just essentially your case. So in this particular day, I was number one in the rotation, so it became my case.
Okay. And once you were assigned as the lead detective, can you tell the jurors where on February 5th, 2024, were you dispatched to?
I believe the physical address was 564 Chapel. It was a field, but the address later became 516 Chapel.
And that addressed the area 564, the 500 block.
Mr. Bass, I need you to
Sorry.
mute everything on, there you go. Thank you.
Of that area that you mentioned, like the actual street address, the street Chapel Road, is that here, City of Atlanta, Fulton County?
Yes, sir.
And can you tell the jurors, were you the first to arrive?
No, sir.
So can you kind of explain to the jurors, I guess, kind of the first things that you observed, saw when you arrived, and then what you did?
No problem. So upon my arrival, once again, I believe I arrived from home. I spoke with the other responding detectives. I believe it was Detective Pulse, Detective Hogan, and Detective Churchill. They kind of briefed me about what had occurred. Preliminarily, what I'd found was there was a body discovered in the field, and upon speaking to other detectives, we also discovered that there were 911 calls in reference to other incidents that were in the same general area.
Okay. And while that's pulling up, were there also other members of the Atlanta Police Department zone officers who were present?
Yes, sir.
And when you arrived, and your first initial impressions of the scene, had it been secured?
Yes, sir.
And can you explain to the jurors, and you can see a little bit on State's Exhibit 10, It states Exhibit 10, the general area that you described, that you initially responded to when you got to the scene.
Yes, sir.
And do you see the yellow crime scene tape?
Yes. Yep. Yes, sir.
And can you explain to the jurors, I guess, the size or the area size of like where the crime scene kind of began and how far it went up Chapel Road?
No problem. So as you all can see from the picture, this is an open field. Right there, you're gonna see the items which were later found to be the decedent. You see our crime scene tape there. As far as size, I don't really want to give like a specific size because I don't want to be wrong. It is an open field, but farther down out of view, there's a gas station. So it's essentially from where the field ends, to where the gas station is, up the street. There's a cross street, and then across that street is when you get to another residence, and then that's where 516 Chapel is. So 516 Chapel expands short distance up the street.
Okay. Now, you said when I guess you spoke to the first arriving detective, you said either Hogan, Holtz, or Churchill, you learned of different 911 calls that were made.
Correct.
And can you tell the jurors, did, as a part of your investigation, and maybe not in that moment, were you able to obtain information from the CAD reports related to a call that happened a little after 6 a.m.?
Yes, sir.
And were you eventually also able to listen to the actual 911 call, the recording of the call?
Yes, sir.
Okay. And did you also have the opportunity to do the same thing as it relates to a shots fired call that came in around 6:37 that morning of February 5th?
Yes, sir, I did.
And were you able to do the same or similar things you just described in reviewing the recording?
Yes.
Okay. And can you explain to the jurors, getting that information as part of your investigation, the times, the CAD reports, hearing the call, how that was able to shape or how that assisted your actual investigation as you move forward?
No problem. So once again, given the vastness of the area here, it is a rather large scene. From our 911 calls, once again, the couple that we did receive a 911 call from the address of 516 Chapel, Road Northwest. Once again, that is a short distance up the road. Within that call, the caller advised that they had caught a male breaking into a car and they currently had that person detained. From that call, we also found that the description of the male being detained in that call fit the physical description of the male found in the field. Specifically, there was a black bubble coat that was discovered away from the body that we had found did belong to the decedent. Furthermore, after realizing that there was a call from 516, I did examine 516, and at 516 Chapel, I noticed that there was blood outside and on the steps.
This time, Your Honor, the state's going to tender what's been marked as State Exhibit 4 into evidence. It is the 911 call associated with the previous CAD report for larceny that came in at 6:03 under case number 2403-60402.
No objection.
It's admitted.
And this time around, the state's going to publish State Exhibit 4.
Okay.
Atlanta 911, operator 8481. What is the location of your emergency?
516 Chapel Road. It's a break-in to a vehicle.
516 Chapel Road Northwest. Is this a house, apartment, or business?
You saying, nah, it's a house. Stop moving.
Okay. You said you need the police. Okay. You said you need the police. What's your name?
I'm Timothy Freeman.
Okay. Say that again.
Timothy Sweeney.
Timothy.
Yeah, we just need somebody to come get, try to come get the dude that tried to get into the car because we kind of have it handled, but we just don't want to do too much. So we don't let the
Understood. I understood. I'll get to that in just a minute. Give me just a second, okay? What's your phone number?
I just got the phone. Let me see real quick.
Yeah, sure. And it's a male that tried to break in your vehicle?
Yes, ma'am. All right, the number is 470
Mm-hmm.
923 9703.
470-923-9703. And how many minutes ago did you find him trying to break into your vehicle?
How long ago they were? Like 5 minutes? Yeah, like 5 minutes.
Did he have any weapons on him?
He got a weapon on him? He got a weapon on him? Yeah, he do.
Okay, did he use it trying to break in?
We need help. We need assistance.
I understand that, but I need you to answer my questions so I can let the officer know. Does he have the weapon? If so, which kind of weapon is it?
What type of weapon is it? A knife.
Thank you. All right. Can you give me a description? Is he white, black, Hispanic, or Asian? And what is he wearing?
Black, white shoes, big puffer, some long shorts.
Okay, what color is the puffer jacket?
Black. All black besides his white shoes. With some type of designs on his shorts.
Okay, and white shoes, gotcha.
Can you send us some help, please, ma'am?
I'm doing that, sir. Let me finish the call, please, okay? Okay, and can you give me a description of the vehicle he tried to break in? What's the color, make, and model?
Cadillac Escalade, all black.
All right.
You try to do something else. My dog bone. They let me know. You make a move.
All right. Don't disturb anything at the scene. An officer will be dispatched as soon as possible. Call us back if anything changes. If you have any further information, I'll advise them that you guys currently have the guy with you guys, so they can come.
Yes, ma'am.
Okay?
All right. Have a good day.
You're
Now, Detective Stansel, can you said you work with the Atlanta Police Department for 9 years, right?
Yes, sir.
Can you explain to the jurors, I guess, how calls are prioritized as it relates to when a 911 call comes in relation to a property crime or let's say a person actively shot and bleeding?
I can't speak to how they specifically classify calls, but I do know that a call with a person injured, maybe shot, hit by a car, whatever it is, that does take priority over a property crime in this case.
Okay. Now, in States Exhibit 14, you said that based on the 911 cabinet report and the call that you reviewed, that the person in the field matched description of the person who was described in that call?
Correct, sir.
And can you tell the jurors when you initially arrived to the area where the field is located on Chapel Road, can you explain to the jurors the condition of the deceased person's body, face? Did you notice any injuries?
Yes, I observed that he appeared to be severely beaten to the facial area. Once again, I'm not a medical expert, so I can't attest to what kind of injuries they are. But as you can see in the picture, there would appear to be bruising things within the facial area, consistent with me of a person being assaulted or being beat up Additionally, you see, you know, the stripped, somewhat of his clothing and items and further things like that. So, like I said, based on what I saw, it appeared that the male was beat up pretty bad.
And, you said, was the surrounding area, that we saw in State Exhibit 14, also, searched for any items that may or may not have belonged or you believe to be of evidentiary value for your investigation?
Yes, it was.
Okay. And you said that a puffer coat was found not far?
Yes, sir.
Okay. And with that, we're looking at now, State Exhibit 33. Or 34, is that a close-up of the puffer coat that was found?
Correct.
Now, can you explain to the jurors, as a part of the investigation, did other members of law enforcement, whether it be Atlanta Police or other agencies with canines arrive?
Yes.
And can you tell the jurors, did they search or what did they do? I'll start with that.
Specifically, if I'm not mistaken, I believe that a ATF canine came out. We do have a ballistics canine that comes out. He's a friend of mine, Officer Denninger, but I had contacted him and I found that he was on vacation, unable to come out. And that is what led to the ATF canine coming out. But a dog did come out and search the area.
And upon the search of the dog, can you tell the jurors were any shell casings found in the area?
No, sir.
Can you describe, if you can recall, the general or the area in which the canine was searched or was taken around?
If I recall correctly, it was condensed to the secured area of that field.
And around where the victim, were you able to determine the victim's identity?
Yes, sir.
And can you tell the jurors, through your investigation, who were you able to determine the deceased person to be?
I believe the deceased person's name was Cordarius Skelton.
And as you in your investigation kind of did the initial search of where Mr. Skelton was found and active with dogs, the canines to the search was a weapon or any sort of knife found on or near Mr. Skelton?
No, sir.
Now, you mentioned earlier that based on what you had learned through your investigation about the 911 call from 516 Chapel Road, I guess that became an address of interest.
Yes, sir.
You explained to the jurors why and then what you did with that information.
No problem. As stated before, given that there was a 911 call there, it's only normal to, go to that location. From the 911 call, like I said, the male that the decedent, Cordarius Skelton, did match the physical description given by Timothy Dennis. For that reason, I said, okay, you know what, that person that they are detaining at this location may indeed be the decedent there. That led me to travel to that address, and that is where I observed what I believe to be blood on the front, near the front of the residence.
When you traveled to that address, can you tell the jurors, was there a black Escalade SUV in the driveway?
No, sir.
Okay. And at any point when you traveled to that address, did you attempt to make contact with anybody who could have been home?
Yes, sir, several times.
Okay. And did anybody come to the door?
No, sir.
Can you tell the jurors when you're on scene with the other members of the homicide unit, are you actually able to get the information from here would be State Exhibit 3, the CAT report?
Not immediately. So like I said, we usually get it at a later date, but like I said, we can get basic information from the CAD. We can view it.
And so in viewing it or being able to get basic information, are you able to get the phone number that was provided on the 911 recording that you just heard in State Exhibit 4?
Yes, sir.
Tell the jurors while on scene and receiving that information, did you attempt to make contact with that phone number?
I did.
And were you able to successfully reach it? Can
No, sir, I was not.
you tell the jury why not?
No one picked up the phone.
Now, as you're on scene in between the areas of 516 Chapel, all the way down to the Exxon gas station, can you tell the jurors, do you canvass for any video surveillance footage?
Yes.
And explain to the jurors kind of how that works and how you determine what is relevant to your investigation.
No problem. So given the crime scene that you had all seen was the field, and now we know that it's 516 Chapel, we are essentially isolating what we're looking for to that general area. What helped us in this case was on the back of the Exxon gas station, there was a camera, and upon viewing the camera, we did see that you did have a visual of the field. For that reason, we isolated our investigation to that, and we kept it at that because once again, we knew that based on a call from 516 Chapel and where the decedent was found, those were our crime scenes and the main points of interest.
Okay. And the footage is that you were able to, or the camera that had footage, you were able to determine was relevant to your investigation. Can you describe to the jurors, did you get 5 minutes? How long of footage did you request and did you receive?
We had hours of footage. If I remember correctly, we obtained footage from before the 911 call up until the time in which EMS and fire arrived and the body is actually discovered.
And the times that you kind of referenced as points of interest for your investigation, you said from the 911 calls, which calls are you referring to?
I believe it would be the original shots fired call.
And that one, that would be State Exhibit 4, State Exhibit 5, that was made around 6:37 in the morning.
Correct.
And can you describe to the jury before we play it, the quality of the video surveillance footage? Is it 4K where you can see, every aspect of everything, or is it of poor quality?
I would call it poor quality. Not terrible, but poor quality.
And can you describe to the jurors, even with the quality that you described, how, I guess, it assisted in the investigation that you had just begun?
No problem. So it assisted in our investigation by giving us a blueprint of kind of how things played out and where our crime scene kind of plays into it. Based on my viewing of it, I and others, we viewed it and it appears to show figures coming from up the hill, which is where the address of 516 Chapel is, coming down the hill, coming near the fielded area where the decedent is later found, and then leaving the area. While the video quality is not the best, passing vehicles illuminate and it allows us to kind of see the figures.
I'm gonna attempt. It's over here. Your Honor, if Detective Stansel keeps his voice up, permission for him to kind of come towards the screen, because that's the only way.
Sure. And Mr. Bass, if you want to get up so you can see it better, you may be able to see it fine from where you are, but if you want to relocate as well, feel free.
Now, you could just, again, just kind of orient the jurors, what we're looking at as it relates to where we are, as it relates to the incident scene and where Mr. Stansel eventually.
Once again, I do apologize for the noise.
Sorry.
Yes.
Please, jurors, stand so you can see it. I know we're switching things up on you. And if coming out of the jury box would help, you can arc around a little bit, just sort of stay near the jury box.
So, once again, I do apologize for quality time, that's what we did try. What you see here, that's the Chapel Road, right? That's the road of importance here. This poorly illuminated area is gonna be the field where Mr. Skelton was located. Up this hill or up this roadway, a short distance is the address of 516 Chapel. It's important to note that from what we observed from the video, we do believe that we have figures coming down this stretch of area and then proceeding to come to the field.
I'm sorry, proceeding to come to,
To the open field where Mr. Skelton was found in.
And can you explain to the jurors when and about what time? Refreshing your recollection of the report would help.
Yes,
Help
sir.
see the figures.
Yes, sir. Can you see?
Your Honor, can you stand next to me?
That's up to Deputy Gordon. Can Mr. Dennis stand over by Mr. Bass to see the screen? Yes, sir?
I believe if we go to the 6:32 AM mark video. So from the 6:32 mark, which is being played now, you can vaguely make out two gentlemen walking down the sidewalk area here. Like I said, it is kind of hard to see, given I'm giving you all distance, but like I said, when we viewed it close up on the computer, it makes it easier. What helps is the passing vehicles. So additionally, from the 6:32 mark, we then can get to the 6:34 mark, where a vehicle passes and the headlights actually slightly illuminate figures.
For the record, I'm gonna move it to 6:34 AM.
Right back, yeah. So I played that entirely. So we're looking at the 6:34.44 mark, which is 44 milliseconds. So you see one vehicle, but then a short time later, you see another vehicle pass. So right back in. So right back when you see the back to my office.
So I wanna focus in the next second. See this area right here underneath where it says, I can't be quarter to camera 32. Can you tell the jurors, at some point, do you see people begin to move in that area?
Yes, what you from that point, what you see people begin to see, you see them moving back up towards 516 Chapel, back up. Right back, pause it. So if you look closely there, that figure there, you look, that figure actually is moving forward. That is one of the persons that is eliminated. We believe there are two. Adam, if you run it back, maybe half a second. So the jury can see. If you look again, you'll see what I believe to be two figures. You'll see this light, this big come into play, and if you look closely in the corner, it illuminates what I believe to be two figures. Right there, walking towards the top of the hill. It's important to note that Mr. Skelton is discovered down in this general area here. So based on my investigation, what I believe, you two persons that are.
Your Honor, I would ask the witness to wait till there's a question.
Okay, fair enough. Are we done with the video for now? Or do you have more for Detective Stansel and the video?
Just had a couple more questions about the video. So Detective Stansel, in the area that we were just talking about, kind of the corner where six to the two, where it's kind of catty corner, camera 32, where it says that.
Yes, sir.
Can you tell the jurors at about 5 minutes and 15 seconds into the video, do you see what would appear to be a muzzle flash?
Yes,
Is it something that's very quick?
yes.
Now, Detective Stansel, have you had an opportunity to look at the video using this DLC player where you can kind of zoom into different things as it relates to what you see in the exhibit?
Yes, sir, I have.
Okay, and is that what helped you assist in finding the figures that you talked about?
Yes, sir.
Okay.
So, as noted before, with a better view, you do see figures walking, out of the general direction. And as you look closely, you can see that it is two persons walking away from that area. And they're much more clear right there.
Okay. Okay, you can see. Now, you said you got hours after the 6:30 mark. Did you review all of the footage, kind of how we just did painstakingly as part of your investigation?
Yes, sir, I did.
Okay. And can you tell the jurors, at any point during your review of the video surveillance footage, do you see, after the 6:37 911 shots fired call, someone come all the way down past towards the Exxon?
No, sir.
Now, I want to be clear, as you reviewed or were able to view the footage we just viewed, you couldn't see anybody's face, correct?
Correct.
Based on that viewing of that footage, were you able to make an identification in that moment?
No, sir.
Okay, why not?
The video is not the best quality. Not to mention, it's terrible practice to identify someone solely on video.
And did you use the video as a tool kind of to continue and further your investigation as it relates to canvassing for any possible additional video footage?
Yes, I did.
Were you able to locate any additional footage?
Cameras, but no footage.
Now, I want to talk about the cameras at the Exxon. We've seen the one that used the field. Was that the only camera that faced in that direction?
Yes, sir.
And can you tell the jurors, did the Exxon, like many other gas stations, have any other video surveillance cameras like inside?
I believe so. They did. Yes, sir.
And did you pull the footage, or did you ask members of Homeland Security with APD to assist with that?
Members of Homeland Security units pulled, I believe it was Investigator Teague, if I'm not mistaken.
Okay. And did you tell Investigator Teague to request or see if he could download footage from inside the Exxon?
No, sir.
And can you tell the jurors why?
No problem. Once again, given the information that we had at the time, nothing led us to believe that inside the store was a matter of importance. The decedent was found in the fielded area. The 911 call comes from 516 Chapel. The store itself is never actually referenced. So it was my belief that the interior of the store video cameras were not of substance. But I wholeheartedly do believe that if the investigation would have led us there, we would have just downloaded video from inside the store.
And through your investigation and, you know, canvassing for witnesses and going through, as you referred, 911 calls that were in the time period, had there been any complaints of any disturbances at the Exxon?
No.
Now, as you continued, you tell the jurors, were you able to make contact or speak to any witnesses on the Chapel Road that you had been canvassing?
Yes, sir, I was.
And can you tell the jurors, did you speak to Mr. Saul, James, or Jaime, depending on how you pronounce it?
Yes, I did.
Okay. And can you explain to the jurors, where did you speak to Mr. Saul?
At his residence.
And where was his residence?
I believe it was 503 Chapel, if I'm not mistaken.
And can you tell the jurors that address, whether it's, where is it in relation to 516 Chapel Road?
No problem. So 516 Chapel is towards the, it's on the left side of the street. If you're looking towards the gas station, it would going to be on the left side of the street. So it should be noted that the houses on the right are kind of at an angle, and it would be three houses down on the right side from 516 Chapel. But standing in that area, you can have a straight field of view to 516 Chapel.
Okay. I know this isn't a great picture, but I want to show you. Well, I'll come back to it, but were you able to communicate with Mr. Saul?
Yes, I was.
And can you tell the jurors, did he understand English?
Yes.
And did he at times ever speak to you in Spanish, or did he, were there times that you, in communicating with them, believe that he didn't understand?
In my communication, no, I did not believe that he did not understand English. Minus the accent, I believe he did have a grasp of the English language.
And without telling me what he said, was he able to provide you with information that you were able to use moving forward with your investigation?
Yes, sir.
Okay. Now, after speaking with Mr. Saul, can you explain to jurors kind of your next steps as it relates to the scenes that we've been talking about?
No problem. So after speaking with Mr. Saul, once again, the address of 516 Chapel became an even more of an address of importance, given the statement that he had made to me.
And you said that you attempted to make contact with anyone who would have been in the residence. Can you tell the jurors, were you able to eventually get inside the residence?
Yes.
Before we move to getting in, were you able to, or did anything on the exterior of the home catch your attention to believe that could help with your investigation?
Yes, specifically, there was the blood and what I viewed to be cameras affixed to the property itself.
Okay. And when you and other members of the Atlanta Police Department, I guess, were outside of the house and noticed the video surveillance, actual cameras, was anybody able to see, were you able to see inside the home, front door or windows?
Slightly.
Okay. And at that point, were you able to see did you see anybody inside?
No, sir.
And as, I guess as a response to seeing those cameras that were fixed to the outside, can you tell the jurors, what were your next steps?
No problem. So our next steps from there was to obtain a search warrant for the property, specifically for surveillance footage, surveillance cameras, DVR box, and any other items of evidentiary value.
And once you were able to get inside of the home, can you tell the jurors about the video surveillance equipment or its ability when you were able to get inside?
While we were able to physically see the box and things like that, we weren't able to access the videos on it. So I wasn't able to, like, you know, scroll through it to see what was going on like that. No, sir, I was not.
And ultimately, as it relates to the video surveillance equipment and the cameras from that home, were you able to get any either audio or video from that system?
No, sir, I was not.
Now, can you tell the jurors inside the home, or was there anybody inside the home once you and other members of the Atlanta Police Department got in?
It should be noted that we did not make entry first. Members of the Atlanta Police Department SWAT team actually executed the search warrant for the property. It should be noted that when SWAT executes search warrants, they do use devices that amplify sound to ensure that if anyone is inside the residence, you know, they know that the police are outside, you need to come outside, things like that. So we were not the first to make entry. But during SWAT's entry, they did come into contact with a female that was located inside the residence.
Okay, and what's her name? Chelsea Davis?
Yes,
You tell the jurors upon her being located inside the home, was she taken to the Atlanta Police headquarters down the street to be interviewed?
she was.
And can you tell the jurors, was she in handcuffs?
I believe she was shackled by her ankle, yes.
So there's why, at that point, Ms. Davis was placed in handcuffs or detained.
No problem. She was detained. We were not sure what her involvement with this situation was. We only know that 516 Chapel is an address of importance. We know that there's blood outside of the residence. We do not know what part that she plays, but we do recognize that we do need to get a statement from her. So she was detained inside the interview room.
And at this point in your investigation, was this the first time a female had, I guess, become involved or, I guess, relevant in the moment?
Yes,
Did you hear a female on the 911 call that we listened to in State Group 4?
I did not.
Okay. And at any point, had anybody reference seeing a female outside of 516 Chapel Road during the relevant time period we've been talking about today?
No, sir.
And did you ultimately interview Ms. Davis at headquarters on February 5th?
I did.
And ultimately, was she released that same day?
Yes.
And were any charges taken out in regards to Ms. Davis and her involvement on February 5th of 2024?
No, sir, they were not.
And I guess I'll ask you, Ms. Davis, was she able to provide you information that was helpful or relevant to your investigation on February 5th of 2024?
No, sir.
And can you describe to the jurors Ms. Davis's physical condition when you first met her that day?
She appeared to be groggy, almost as if like she was sleeping. I believe, if my memory does serve me well, she did advise that she had been sick and that she also sleeps with earplugs in. That's why she didn't hear any of the commotion that was going on.
And during this time period, are you able to ascertain other people who lived at 516 Chapel Road?
Yes.
And you've already spoken about Ms. Davis as well as the individual who had called 911. You said you tried calling that number, right?
Yes.
Tell the jurors through your investigation, who were you, and who else were you able to determine was living at that residence?
Through my conversation with her, she advised that she was staying in a room with her boyfriend that she only knows as Pressure. She advised me that she'd only been there for a short time and she didn't really know his name, but she did say that Pressure stays there with his little brother and his father.
And was she able to give you a phone number for the person she called Pressure?
Yes.
And after the interview with Ms. Davis was complete, can you tell the jurors, did anyone reach out to you in regards to the person who you knew as Pressure after that interview?
Yes, someone did.
Can you explain to the jurors who that person was and how that circumstance came about?
I believe that would be retired APD Sergeant Daniels. While we were back at headquarters, Sergeant Daniels had actually called homicide directly and advised that he had been contacted by a male he was familiar with by the name of Brenton Dennis. And through that, Brenton was trying to figure out why the police were at his house. He said that Brenton advised that he got into a fight, but that's it. And he couldn't understand why the police were at his house.
And was former Sergeant Daniels able to provide you a phone number for Brenton Dennis?
Yes,
And the number that was provided to you by former Sergeant Daniels and the number that Ms. Davis provided you for repression was that the same number?
yes, sir.
And can you tell the jurors after receiving the number twice, did you attempt to make contact with Brenton Dennis?
I did.
And can you tell the jurors on February 5th, when you began to make contact, were you able to reach or connect with the defendant?
No, sir, I was not.
And explain to the jurors, did you call just once? How many times did you call or make those attempts?
I called a few times actually. Made it a point to reach out. I don't want to seem as though I did not follow every lead. I did reach out multiple times.
Okay. And the times that you reached out, can you remember, were you able to leave a voicemail or contact information for yourself to reach back out if you was to receive any messages?
Yes.
And can you tell the jurors, were you able to make contact with the defendant, Brenton Dennis, soon thereafter?
I was. Brenton actually reached out to me in the early hours of the next day. We spoke and I advised him, hey, I need to talk to you. And Brenton stated he would come down to headquarters and speak with me.
Okay, and the very next day, would that be February 6th of 2024?
Yes, sir.
And did he come down and speak with you?
He did.
And can you tell the jurors where and approximately if you remember what time that happened on February 6th?
I can't be specific with the time. I do know it was probably in the afternoon. The interview was conducted inside one of our interview rooms. It should be noted that given that he had come down there on his own, he was not detained within the room. He was not shackled within the room. There were no handcuffs used. And I made it a point to tell him, hey, man, you're free to go at any given time.
Okay. And at that point, when he arrived, did he agree to speak with you?
Yes, he did.
And you said that you made it a point that he was free to leave. He didn't have to be there, things of that nature.
Yes.
Can you tell the jurors what are Miranda warnings?
The Miranda warnings are the warnings of which the courts advise that we are to give to suspects that are either detained or in custody. At this point in time, Mr. Dennis was not detained, nor was he in custody. I just made it a point to read him his Miranda rights.
Okay. And can you tell the jurors why do you make it a point to do that?
It's any evidentiary value. I don't want it to be in a situation where something of importance is said and then the courts then suppress it and advise that, he was in a room, there were no windows in the room. He felt as though he couldn't leave. So I made it a point to read him his Miranda rights so that I could ensure him that you don't have to talk to me. You don't have to be here right now. But if you are agreeing to speak with me, let me just keep this as copacetic as possible and make sure that you know what's going on.
And can you tell the jurors after he came in and you read his Miranda warnings, did he agree to speak with you?
He did.
And for the Miranda warnings, do you have anything that you refer to or read from when you're giving those warnings?
Yes, I personally have a Miranda rights card.
And did you use that card and read him those warnings verbatim?
I did.
After reading him the card and telling him the rights, did he appear to understand things that you were saying, the rights that you were reading?
He did.
At any point, did he indicate that he didn't understand?
No, sir.
Okay. And after reading those rights, the warnings to him, did he agree to speak with you?
He did.
Okay. And I know you said you're at headquarters. Can you describe to the jurors kind of the scene in which the room that y'all are in as it relates to the interview with Mr. Dennis?
No problem. It is a smaller room that is equipped with cameras, 2 cameras to be specific, one on one wall, one on the top. These cameras pick up both audio and video footage. Within the room, there's a small table and there's some, depending on the day, a couple chairs, no chairs, it all depends. And affixed to the floor is an area in which a leg shackle is apparent. But once again, Mr. Dennis was not fixed to the leg shackle.
And now we obviously know that you and Mr. Dennis were in the room. When you read him the warnings and when you spoke with him, was it just the two of you or anybody else?
I believe it was just the 2 of us.
Okay, and And I want to show you what's been marked as State's Exhibit 65. The entry. And do you recognize State Exhibit 65?
Yes, sir.
And how do you recognize State Exhibit 65?
I recognize this exhibit because I viewed the contents of the exhibit.
Okay. And is your signature, I guess on the outside, showing that you are representing that you viewed it?
Yes, sir. Right here on the stakes exhibit, I signed it and dated it.
And did what you reviewed on the State Exhibit 65, was it a fair and accurate copy of the actual interview that was done with the defendant, Brent Dennis, February 6th, 2024?
Yes, it is.
Sorry, state agenda was marked the State's Exhibit 65 in evidence.
Any objection to state 65, Mr. Bass?
No.
Okay, it's admitted, consistent with a ruling I've made and entered into the docket.
This time around, the state is going to publish State's Exhibit 65.
All right.
Your Honor, good temper break.
The statement's not real long. I was thinking we'd do it right after the statement, if you can make it that long. Okay.
For the record, I'm gonna move to 6 minutes and 50 seconds into State's Exhibit 65 and Secretary Stansel enters the room.
Sorry. Catch my breath.
Man, no, I don't even talk to the police.
I mean, so this is why I give you credit, right?
Yeah.
Clearly, you got a story to tell, right? And I get it. And my whole thing is, I want to make sure that you get to tell your story.
Yeah.
But I gotta go through a few things, okay?
Okay.
So you're free to go.
Yeah, I'm okay.
But I still got them right after you, okay? You just gotta understand that. So you've seen the show before.
Yeah, I'm okay. Bro, I've studied a lot. I studied the whole judicial branch. I studied the whole branch of government.
Yeah, so I got you. Yeah. Let's write to mention out. The only thing you say will be when there's evidence against you, you're entitled to have a lawyer now, and have ears to question now is the time of the question. You do not court a lawyer, won't be appointed for you without cost, and he or she may be present all the time during questioning. You can decide at any time to exercise these rights and not answer questions, any questions or make a statement. You understand these rights? You wish to talk to right now with our lawyer.
Yeah.
Bet. So let's get some quick things up here. Britton, Marquez, Dennis, you just stay in Elwood?
Yeah.
That 3750, that's where mom stay, right?
Yeah.
Okay, you stay with your mom?
No.
Okay, you just use that address? Okay, gotcha. Is that one of your business addresses?
That's what I
That's
just.
okay, okay, yeah,
Yeah.
okay. That's not fake business address, gotcha.
Okay, so let me put you, I don't know how you know, I don't know if you know.
Yeah.
But what I'm saying, yeah, I am the executive of this strong man. You feel me?
Yeah, listen, I saw the letters, you got a lot,
That's it.
you and your dad got a lot going on, and even with the breeding, those aren't low-tier dogs.
Exactly.
That's a purebred friendship.
Exactly, bro.
Like, those
the foundation of friendship.
those are hard to come by.
Exactly.
And I don't think with the purebred, you don't have to nose it, because I know they have nasal issues and shit, so, y'all own it. And then also, will catch. I know your dad's got the lawnmower thing, I got hustle. So, I can manage. So, that being said, bro, walk me through that.
Alright, this what I'm. I come out my door to go to work.
Right.
This nigga getting out my truck.
What was your truck parked?
in the driveway.
Okay.
So boom, I'm coming out, you know, I'm gonna go work.
Yeah.
So I come out the door, I guess he was like, oh shit.
I'm gonna stop it for a second, because it just skipped an entire minute and a half.
You are, or you're saying it did?
It did, but. I'll just keep going.
You feel me? So he trying to get out the truck, that nigga got a knife. So when he trying to get out the truck, you know. I don't do 10 years in total, you see what I'm saying? So I don't know what doing, you know. Then he want me out, all right, boom. So I ain't got nothing. I'm coming out to go to work. You feel me? Shit, so boom. The nigga swing the knife at me, bro. Swing the knife, I do one of them.
Yeah.
And when I grab, boom, he get back up, but when I grab him, he drop the knife.
Okay.
So that was it right there.
Okay.
So boom, now I wanna fight. Fuck all that, you feel me? So I let him get back up. Nigga, give me your money, you gonna break my shit, you feel me? Give me your money. So boom, I just he hit me in the lip. Yeah, so he hit me in the lip. Boom. We got fight, long story short, so I beat him up. I told him, I don't beat him up. I told my little brother, call the police. You know what I'm saying? So while my little brother called the police, I'm down on the ground like shit. I'm beating him up, you feel me? So the police asking all the questions, and little brother, he tell him. So shit, when I get calm, long story short, bro, when I ain't calm, I ain't got no wind to keep on trying to hold them and beat no man up and wait for no police to get here. So we touching, you know, cause I told him shit, bro, I'm trying to save you, bro. No nigga murder you, bro. Just tell you the truth. So boom, I'm trying to save you. So boom, I got like this, I'm getting tired, bro, you feel me? So we scuffing. I'm trying to hold him, wait for the police, trying to do right thing. So goddamn, you gotta do. He took off. When he took off, I get my try to go to work. Shit, it was on there.
Alright, what time do you think on that?
Like, I get ready to go to work like 5:30, 6 o'clock. It's what I'm saying.
And just so I'm clear, that's all that.
That's all that.
Alright, deep game.
Alright.
We like 50% of the way there. And that's why I said, you know, a gas station down the street,
Yeah.
gas station got a camera that points right at your house.
Okay. It don't point
I know
out.
it does, because I got the video from it.
Okay.
So, I ask you, is that all that? Because what I need you to understand is, this is your opportunity to tell the truth, to tell your side. Okay?
Yeah.
And if you aren't like really forthcoming with me, bro, I gotta fill in the blanks with not speculation, but facts based on video evidence. And I would rather you tell me what happened, and that way I can with video, I bet that makes a lot more sense. Because what I can tell you is he did not run that. He didn't run that. I can say that right now. He did not run that. How did he get there? Just keep it on, bro. How you get there? Huh? Who took it? It was you and us. There's two people carrying it. It's on video.
Well, I don't know, bro.
But you took it. So you say you took it.
No.
So how you get down?
The lawyer.
You want a lawyer? So, that's it. Cool.
I'm gonna stop it at 12 minutes and 36 seconds into the video. Now, at that point, Detective Stansel, after the defendant asked for an attorney, the interview, as it relates to you asking questions, stop.
Yes.
Okay. And can you tell the jurors at what point when did the defendant, I guess, or what question had you just asked him as it relates to your investigation after he said he wanted a lawyer?
How did he, being the decedent, get there being the field?
And can you tell the jurors his answer to your question was?
Took him.
Then do you remember or recall during that interview at that point, you asked him who helped him?
Correct.
And is that when he stopped answering your questions?
Yes.
I keep going or do you want to take a break?
Is that it for whatever you're going to do next moves beyond the interview?
It does.
Okay, why don't we take our morning break, ladies and gentlemen? I'm going to keep it pretty short because we need to break for lunch around noon. It's not a hard stop at noon, but it'll be around noon. So do what you need to do during the break, other than talking about the case or doing any outside research, and we'll see you back in here in a few minutes. Thank you so much.
All right, observe.
All right, Detective, you can step down. I need to get one thing on the record, but you can be at ease. Everyone else can be seated. During Mr. Gravely's testimony, it was towards the very end when I was propounding the jurors' questions. Mr. Bass had an objection that I asked him to hold. He preserved what his concern was. He wanted to talk about it outside the presence of the jury, which has happened, and I want to make a record of that and then give the lawyers a chance to augment the record if I missed anything. I had asked on behalf of a juror question for the witness to explain a little bit more about the longer list. The question from the juror was, you had said, Mr. Gravely, that not all of the guns on that longer list were not a revolver. How many weren't? And he was going through the list, and he used the word Derringer several times. I asked him what a Derringer was. I didn't know what a Derringer was. I asked him what that was. He said whatever he said, the record will preserve that. And then I moved on to the other question from a juror, which had to do with how small can a revolver be that fires a 38? And there was a discussion about barrel length, et cetera. When we were outside the presence of the jury, Mr. Bass shared with me the concern that he felt like I, the judge, was highlighting Derringer and putting undue or inappropriate emphasis on one thing versus the other. Plainly, that was not my intent. Like I said, I didn't know what a Derringer was, and the witness used a word I didn't understand, and it's well within my rights to say, I'm sorry, what is that? Witness said whatever he said and moved on. But it was in response to the witness's use of the term Derringer that I then asked Derringer, meaning what is that? And the question I had originally asked emanated from a juror, not from me. Mr. Bass, you've preserved any issue I created by my interaction with Mr. Gravely. But if there's more you want to get on the record now would be a great time to do it.
My recollection of the testimony of the firearms expert witness called by the state was that in reviewing a list of possible guns that could have fired the round that he was analyzing, there were abbreviations after several of the types of firearms. Your Honor referenced what a Derringer is. My knowledge of firearms, while I wouldn't qualify myself as an expert, I believe I am accurate in that Derringer is the smallest commonly manufactured type of firearms in the United States. It's my belief that emphasis on that and not other items on the list tilts the scale toward the weapon being smaller than larger. I objected at the time, and that's the extent of my objection.
Got it. Okay. And I'll just reemphasize, I didn't ask the witness to explain what a revolver is because he'd already done that, or what a semi-automatic was. But that word Derringer hadn't come up in his testimony until he used it. And I simply asked him, what is that? But you've preserved your concern for the record. Mr. Abadi, anything you want to add about or maybe it was Mr. Rao, your witness, anything you want to add about that exchange?
The only thing I'd add is that the objection came as it relates to the when the question the juror asked about the length of the barrel, not as it relates to Derringer. And more importantly, the question actually highlighted about the Derringer that it had two almost barrels, where therefore making it even less like the gun that Miss Davis described, which I believe is the whole point of the objection or this reporting into the record. So I would say it did the opposite.
Okay, well, you all have made your record. Thank you for doing that. We'll take what remains of the short break now. Anything else from the state before we start that break? Mr. Bass, on behalf of the defense?
Nothing.
Okay, thank you. See you shortly.
How long?
5 minutes.
Back in 7?
We have Mr. Dennis. I don't know if he even left the courtroom, but he's back in court with his lawyer, Mr. Bass. Our prosecutors are here and Detective Stansel is ready, adjusting his spine, but he's good to go. Are we ready for the jury, Mr. Abadi?
Yes, sir.
Mr. Bass?
Yes.
All right.
All right, for the jurors. Deputy President of Council.
Thank you, Deputy Gordon. Everyone else should be seated. We will continue with the direct examination of Detective Stansel.
During your testimony about you receiving a phone call from former Sergeant Daniels to go back,
Yes, sir.
and based in your experience with the Atlanta Police Department, was that an unusual experience for you?
Yes.
And after the defendant was interviewed by yourself, who just watched, can you tell the jurors, did he get to go home?
Yes.
And can you tell the jurors, were warrants taken out on that day?
No.
And can you explain to the jurors or talk to the jurors how receiving that call from former Sergeant Daniels played a role in this part or at this time of your investigation?
No problem. So we all have bosses. Being that retired Sergeant Daniels did reach out and contact had been made between him and Britton Dennis, my bosses made it a point to say, hey, before you go ahead and take out warrants, why not go talk to Sergeant Daniels and see what he has to say?
And can you tell the jurors after speaking with the defendant, did you, in the days coming, go speak with Sergeant Daniels?
Yes, sir, I did.
And can you explain, I guess, where and circumstances of that conversation?
No problem. I, along with another detective, met Sergeant Dennis, retired Sergeant Dennis, at a Starbucks in South Fulton.
And in speaking with him, did he provide you with the same information or similar information that you had received when you spoke to him over the phone?
Yes, sir, I did.
Okay. Now, after February 6th, when you speaking with the defendant, can you tell the jury, did you go back to 516 Chapel Road in an attempt to make contact with any other occupants of the home?
Yes, sir, I did.
And did you do that on February 11th?
Yes.
Tell the jurors, I guess when you got there, were you able to make contact with anyone?
No, sir.
And can you tell the jury, when you got back over to the 516 Chapel Road address, was there any cars in the driveway?
Yes.
And tell the jurors what cars you saw in the driveway.
There was a black, older model Cadillac Escalade with tinted windows that was, I believe, registered to Britton Dennis.
Okay, I'll show you what's been marked as State's Exhibits 42 and 43. You recognize State's Exhibits 42 and 43?
Yes, sir, I do.
And how do you recognize the photographs 42 and 43?
State's Exhibits 42 and 43 are photos.
Don't show them to the jury yet. That's okay.
Sorry.
Put them flat. They're not in evidence yet. Hopefully they will be soon since you showed them to the jury.
Is the photograph, did you take those photographs?
I did.
And are they photographs of the vehicle that you just described, the black Cadillac Escalade that you saw at 516 Chapel Road on February 11th?
Yes, they are.
This time around, the statement tender was marked as State's Exhibits 42 and 43 in evidence.
No objection.
They're admitted.
Now, Detective Stansel, when you were at the home and you saw the car, can you tell the jurors, did you notice any damage or anything, broken windows relates to that Cadillac Escalade?
No, sir, I didn't.
And in your review of the car and observing, did you notice any damage to the physical body or any part of the vehicle?
No, sir.
Okay. Now, I just want to go back to during that interview that you did with the defendant on February 6th. Did you notice the defendant having any injuries of any sort on his face or his body?
No, sir, not that I viewed.
Now, after you spoke with Sergeant Daniels, and that was on February 13th,
Yes.
can you tell the jurors, did you continue to attempt to make contact with the defendant's brother, Timothy Freeman Jr., and then his father, Timothy Freeman Sr.?
Yes, sir, I did.
Okay, and explain to the jurors kind of how you were doing that and if you were successful.
Phone calls, reaching out to the numbers from the 911 call and other numbers that I found. I did locate a number for the father and made contact with him, but to no regard, nobody answered the phone. And like I said, I did go by the house, physically knock on the door. I even left a card on the door to advise them that I came to the house and to contact me.
Okay, and in days coming, February 15th, can you tell the jurors, did you take warrants for the defense arrest?
Yes, sir, I did.
And can you explain to the jurors, tell the jurors which warrant that you swore out?
After a roundtable discussion with some senior detectives, I swore out murder warrants for Brenton Dennis, aggravated assault warrants for Brenton Dennis, possession of a firearm by a person convicted of a felony, possession of a firearm during the commissioning of a felony, and tampering with evidence.
Okay. And after you have those warrants or you swear those warrants out, can you tell the jury what do you do as it relates to the investigation moving forward?
So upon the warrants being sworn out, we then have to put those warrants on the system, GCIC. So if any law enforcement entity makes contact with Mr. Dennis, then they know that he is wanted for his outstanding warrant and they know to take him into custody. Additionally, I flagged that vehicle that he was operating so that if any person runs his tag, they do know that there's a wanted person inside the car. That packet is then completed and submitted to our fugitive unit.
Okay. And in the days coming or the next day on February 16th, did you get information or a notification that Mr. Dennis has been placed under arrest?
Yes, I did.
Okay. Just have a few more questions, and I want to ask a real specific one. During the search of the 516 Chapel Road address, was a 38 special firearm found at the home?
I believe there was a revolver found in the home. I do not want to be wrong and state that it was that.
Mr. Bass?
I'd like to be heard outside the presence of the jury.
Okay, we'll do that a little bit later, but you've preserved a concern you might have.
Now, after Mr. Dennis was arrested, can you tell the jurors that you attempt to make contact with the company that serviced the video surveillance cameras for 516 Chapel Road?
Yes, sir, I did.
And in making those contacts, were you able to or successful in obtaining any footage from that home?
No, sir.
And at any point after you had made several attempts to contact Timothy Freeman Sr. and then Timothy Freeman Jr., father and brother of the defendant, did they ever contact you back?
No, sir.
I believe that's all the questions I have. Thank you, sir.
Mr. Bass, cross-examination?
Yes. Once you found the body of Cordarius Skelton in the field near the Exxon service station, Was it clear to you that you were dealing with a murder scene, a homicide?
Yes, sir, it was.
Did that impress upon you the necessity to be accurate and complete in all of your recordings of any conversations or observations you would have or make?
Yes.
Were you accurate and complete during your investigation?
What specifically are you referencing?
Were you accurate and complete during the course of your investigation?
I believe I conducted a thorough investigation, yes.
Did you have conversations with any member of the Fulton County District Attorney's Office, any law enforcement officers regarding this case after this Monday,
What do you mean this Monday? Talking about this past Monday?
Monday of this week? Did you speak with anybody? Did you speak with anybody this week about this case?
Yes.
Who did you speak with?
I was contacted by, I believe it's Assistant District Attorney Adam Abadi.
When?
I can't recall the day, but he did call me.
You don't know, today is Thursday. You don't know if it was Monday, Tuesday, or Wednesday, or today.
I know it was early this week. I can't remember the day specifically. I do remember being at home playing video games, and I believe he called me.
Was it in reference to the testimony of James Campbell that he felt the need to call you?
No, I'm not even sure who that is.
What about Saul Jaimes?
No,
That name or your testimony regarding Mr. Jaimes come up in your conversations with any member of the Fulton County District Attorney's Office?
I believe I was advised that he did testify, but there was no specifics as to what he testified to.
And did part of that heads up you got before testifying today include notifying you that all along the address you were listing was wrong?
Part of it, yes, I believe. There was the incident where I was advised that I had the wrong address, but that was today.
During your preliminary hearing, you stated it was 511, correct?
I believe so, yes.
And that is wrong
Correct.
and incorrect and incomplete.
It is incorrect.
Stated in your supplement that it was 511, correct?
Correct.
Similarly incorrect.
Correct.
You stated that he lived across the street, similarly and intentionally misleading, correct?
I don't believe so. 503 is the third house on the right, and 516 is located across the street. So it is across the street from the residence.
Were you attempting to lead anyone reading your report into thinking that he lived directly across the street?
No, sir, because if I was doing that, I would have referenced the house that is on the first house on the right.
Who you did talk to and they didn't see anything?
I believe so, yes.
Did you write that in your report anywhere?
Did not.
The house next to the house you just referenced, did you speak with anybody there and fail to include them in your report?
I believe we attempted to make contact and we were unsuccessful.
How many times did you attempt to make contact in a homicide case with potential witnesses?
That day, we went multiple times. But we were also on the scene for hours. So we make it a point that if anyone comes out and wants to speak to us, they can always come and speak to us. Police were present in that area for an extended period of time that day, multiple hours.
So if somebody had seen something, went to work, you wouldn't bother to come back the next day and try to catch them?
If someone had seen something and went to work, I would have made it a point to reach out to them if they advised that they need to speak with me, yes.
You're post-certified,
I am,
formerly a patrol officer with Atlanta Police?
correct.
How long have you been a detective?
2 years, I believe.
Are aware of the efficacy of wearing recording devices during important interviews, correct?
I am,
A homicide investigation would be an important exercise of your investigative capacities, correct?
correct.
People you speak with during a homicide investigation, those conversations ought to be memorialized in a recording or video, correct?
Correct.
Where is the recording or video of the interview with the person directly across the street from 516 Chapel?
I myself do not wear a body cam. I wear in a suit jacket. I wear a recording device. It was not documented because we did not obtain a statement from her.
Did.
We did not.
That I didn't see anything is a statement, correct?
I wouldn't call that a statement. I would call that a person advising they don't want to talk to you and they didn't say anything.
But if they didn't say they didn't want to talk, they just simply said, I didn't hear a shot. Is that evidence that they did not hear a shot?
You could say that, yeah.
If the person next door didn't hear a shot, is that not evidence that they did not hear a shot?
That is important, yes.
And the person further away who claimed to hear the shot that the people closer didn't hear, that was recorded, correct?
No, but at the same time, we're focused on the person that did advise they did hear something. It's early in the morning. Not everyone hears things. Some people are heavy sleepers than others. So you can't assume that everyone heard the same thing.
Your impression of Chastity Davis, you were with her for over an hour. You were able to gauge her demeanor. Is it your impression that she was legitimately very sick?
To her own statement to me, she did advise she had been sick, yes.
And did you note in your report that you also believed she was sick?
No, but it's documented in the recording for the record.
Provided her hot tea, correct?
I'm not sure. I can't recall.
She was coughing throughout the hour-long interrogation which she was shadowed, correct?
I believe so, but once again, I can't recall.
Holding her throat, correct?
I believe so, yes.
You mentioned nightfall, correct?
Yes,
You mentioned wearing head or earphones because it's hard to sleep with dogs barking, correct?
I believe so, yes.
And when the SWAT team were banging on the door, SWAT doesn't knock lightly when they're coming in to execute a warrant in a homicide investigation. They knock loudly, don't they?
Yes.
And she didn't hear that.
To her statement, she advised she did not hear.
Same morning of the incident,
I believe so, yes.
same location where she was initially.
516 Chapel, yes, sir.
She's not hearing that.
So you asked that and he answered.
SWAT comes in and she's where at that point?
I was not privy to them. I was not in the stack. I do not know specifically where they were. I do know they've made contact with her.
Was she presented with a copy of the search warrant?
No,
Was she told what the execution of the warrant was pertaining to?
I believe the SWAT operators did tell her that there was a search warrant they were executing as.
For what reason?
Just a search warrant.
You heard numerous times the 911 call made by Timothy Freeman the morning of February 5th, 2024, correct?
I did.
At any point in time, did you ever hear Timothy Freeman telling Chastity Davis to go back into the house?
Not that I can recall hearing, sir, no.
Did you hear the voice of Timothy Freeman?
Yes.
You can identify and put Timothy Freeman on scene.
Yes, sir.
You heard the voice of my client, Brenton Dennis.
Yes, sir, I did.
You can identify and put him on scene at 516 Chapel Road.
Yes, sir.
Father was inside.
That I'm not sure about.
Those would be 3 males.
Correct.
And the other occupant that you knew about, the 4th, was a female.
Correct.
Do you know what time the black Escalade left the driveway on February 5, 2024?
I do not know specifically, no, sir.
Would your utilization of the cameras on the intersection of Donald Hollowell and Chapel Road, or use of the cameras on the front of the Exxon station have provided you additional information as to the passage of the Black Cadillac the morning of February 5, 2024.
Potentially, yes.
Wish you had that information now?
No.
In speaking with Mr. Campbell, did he advise you of the presence of drug dealing activities?
Who's Mr. Campbell, sir?
The second 911 caller who heard 2 shots.
I did not speak with Mr. Campbell, no, sir.
You know who spoke to Mr. Campbell?
I believe Detective Holst did.
Did Detective Holst relay to you what was said in the interview with Mr. Campbell?
I believe she referenced speaking with someone, yes. But I can't recall the specifics of what that conversation was.
As the lead detective, wouldn't other detectives documenting different aspects of the case relay those aspects of the case to you as the lead detective?
Oftentimes, yes, sir.
When would it ever be appropriate not to?
I can't say that it is appropriate not to.
When you state that parties are walking up the hill toward 516, would it not be more accurate to say you believe parties are walking toward Bliss Drive?
I believe Bliss Drive is that side street, but that is relative to the direction of 516. What is important about the video footage is, sir, Bliss Drive is captured. If you saw someone walking down Bliss Drive, which is a road that only goes to the right, you would see them walking down Bliss Drive.
I have shown the prosecutors a copy of what marked Defendant's Exhibit 14. That appeared to you to be an accurate reflection of what I'm referring to as Bliss Drive.
I would not say this is accurate because it does not show the cross street, nor does it show the entire width and length of Bliss Drive.
In the photograph, can you see the Exxon service station that is referenced in all of your testimony?
I can.
Would the other end of Bliss Drive be more relevant or even at all relevant to this?
In this case, it would be because the end of Bliss Drive is Chapel.
What is at the west end of Bliss Drive?
I'm not sure what's at the west end, but I do know it's a T intersection of Bliss and Chapel.
So is it your testimony that Bliss Drive is not relevant unless I show an aerial photograph of the entire length of Bliss Drive?
I believe that it's your feeling that this photograph is relevant. It is my belief that if you're going to show a photograph, you should show the photograph as it pertains to things around it.
The field where the body lies is in that photograph, correct?
Partially, yes.
The Exxon station you reference is in that photograph, yes?
Correct.
But you're saying that photograph is not relevant containing the place where the body was and the Exxon station is clearly seen, correct?
Once again, I can't tell you what you deem to be relevant, sir. What I'm saying is it is important to note that Bliss is a T intersection with Chapel. Chapel is the road in which 516 Chapel is an important place. So I believe it would be important to show myself and the jury where Chapel Road is in relation to Bliss Drive.
Is the walkway that you maintain, you can see shadowy figures walking, evidenced in that photograph?
Partially, yes.
But the photograph is not relevant.
Let's go to a different topic than the relevance of something that's not in evidence right now.
As demonstrative evidence, I would play a photograph.
You would like to publish, this was 14? I understand, but it's 14. I want to make sure so defense 14. Mr. Abate, any objection to defense 14 being admitted as a demonstrative? Okay, then you can publish it.
All right. Can you see the Exxon station at the corner of Chapel and Donald B. Hollowell in the demonstrative aid?
I can see the picture and I can see what you're referencing in the photo. Yes, I can.
Can you see the area where the body was found in the photograph?
No, because the field is not 100% depicted.
If I'm the person holding the camera right here, detective, in what direction is 516?
No problem. So do you mind if I pick up the photo?
I don't mind. It's in evidence now in the sense that it can be shared with the jury.
Bliss, to my understanding, Chapel
Your
run.
point on the screen.
So this is Bliss, to my understanding. Chapel runs that way. It's a T intersection. 516 is behind.
So it's not where the tree is. If I were standing on Bliss, if we assume this is Bliss, facing the right side of the photograph, is 516 to my right
No, so
or to the left?
it would be, so that's why I said it'd be more important to show you a complete photo of how Chapel and Bliss intersect, so you can get a better understanding where the residence is.
It would help, but if you had to, you can't unfortunately mark just on the black part of the screen. In what direction would I go if I was gonna walk off this photograph to get to 516? I understand I don't go to the left.
I'm sorry. So, like I said, it's a kind of a bad, but you could go behind, and it's out of the field of view of this, the way this photo is taken.
516 Chapel Road, you would go behind?
Yes, so in order to get to Bliss from 516 Chapel, you have to walk down
Towards the Exxon.
towards the Exxon. Yes, sir. That's why I
Okay.
said this photo is not an accurate depiction of what we're dealing with here.
Well, engaging on that, but so if I were to walk from 516 to the Exxon, I necessarily cross the Chapel Bliss intersection.
Yes, sir.
Thank you.
All right. So if you're at this Exxon service station, here, walking up the street, correct?
What street are you referencing again?
Chapel.
Yeah.
You're walking up Chapel, where you allege you saw the two shadowy figures. You're walking up Chapel. You're walking toward 516. Are you not walking in a straight line along the sidewalk this way?
I can't tell you how a person walks. Is there a straight shot that will get you from Chapel to the gas station? Yes, and you have to go down Chapel, past Bliss.
Not trying to make this difficult.
Just next question.
Chapel Road is not completely straight, but Chapel Road is a normal road, correct?
Yes, it is. That is a T intersection with Bliss.
And as you're going north on Chapel, before you get to that service station, you're going from Chapel, you're going down Chapel. On the right are the numbers that are odd. On the left are the house numbers that are even. You're going down Chapel. Before you get to the intersection of Donald Holloway, where all the cameras are, there's the Exxon across the street. There's another gas station on the other corner. You're going down Chapel. You can make a left on Bliss or keep going down Chapel, correct?
Yes, because it's a T intersection is what I referred to.
Okay, so when you say the parties are walking up the street to my client's father's house, they could have been walking to Bliss and making that right to the house on the corner, correct?
That's your interpretation, sir, but based on what I view is the males, well, the person's depicted walking straight up.
You never see in your video anybody cross Bliss.
Got a question?
Do you see in your video any evidence of anybody crossing Bliss?
No,
Did you interview or even attempt to interview the residents of Bliss on the right-hand side of Bliss?
I believe, and this is to my recollection, other members or police did attempt to speak with them. But like I said, as I referenced before, I did not.
Who spoke with residents on Bliss and what information did they receive in response to their inquiries?
I'm not sure who spoke with them, but once again, the information was not shared with me.
Before you bring warrants in a homicide case, is it normal police procedure to aggregate all statements received, document all statements from witnesses?
That's best practice, yes.
The house on Bliss, correct me if I'm wrong, has a straight vantage point to where the body ultimately lied, correct?
While they have a field of view, it's heavily brushed area and there's a fence as well. So once again, but I also can't tell you what a person can and cannot see.
And since you don't know, you ought to ask, correct?
I personally believe I asked the necessary questions to the relevant witnesses in this case.
How do you know if a witness is relevant or not, possesses material information or not, is willing to speak with you or not, unless you bother to ask?
One, a person cannot be forced to speak with us. Two, persons are always able to come forward with any information that they have. We encourage everyone to come forward with the information they have. Once again, as I stated before, we were out there for numerous hours. A SWAT team was out there, command post was set up. Any person that wanted to come forward and say that they had seen or not seen anything had more than ample time to do it. The witness that we did speak to did come forward and advise what he did see.
Saul Hines responded when police went to his residence, correct?
Correct.
But police did not go to other residents.
So we've covered this several times now.
Chastity Davis did not respond on her own, correct?
Same. Next question.
Do you possess interviews of anyone that has not been turned over?
All evidence that I have has been turned over.
What about evidence from other investigators working with you?
All evidence that I possess or that what we had has been turned over.
Did Officer Pitts tell you how he knows or how he was able to identify Cordelia Skelton? Yes or no?
Hold on. There's an objection.
Here's that.
Was Officer Pitts able to give you a positive identification of Cordelia Skelton?
I don't recall Officer Pitts's identification of the decedent. My identification of the decedent came from the decedent's wristband or items that he had on his person at the time.
Explain what the wristband was and how it documented who Cordelia Skelton was.
I believe the wristband advised his name and date of birth.
His name and what?
Name and date of birth.
Were the injuries you saw upon Cordelia Skelton consistent with the offense of battery? The bruising on the face, black eyes and such.
Once again, I'm not a medical expert. I'm not a doctor. I cannot tell you what is consistent with what, but based on what I observed, I believe that the decedent in this case was indeed assaulted and battered. Yes.
He was battered.
Yes.
What gives you reason to doubt that Cordelia Skelton attempted to break into my client's Escalade?
Vehicle breaking is pretty cut and dry. I'm breaking into your vehicle. I'm making physical force into your car. There was no breakage of glass observed on the car. What's should be noted most importantly is when vehicle glass is broken, specifically tinted window glass, they don't give you another tinted window glass. They give you a clear glass. So oftentimes what we'll see is when people get their cars broken into and it's tinted, You have fully tinted windows and one window that's not tinted. That is what I looked at and said, you know what? I don't believe that this vehicle was actually broken into.
Isn't there a category of automobile entry commonly known and referred to by the Atlanta Police Department as a door pull?
Yes,
A door pull does not involve what you just testified to, broken glass and window tints and all of that, correct?
correct.
A door pull is simply as it sounds. A person attempting to break into a car's in the area would walk down and see who left their door or car unlocked to get in.
Yes, pulling on the doors.
If you pull the door of a car that's not yours at 5 o'clock, 6 o'clock early in the morning, get into the car and are caught by the occupant, would that qualify as someone's breaking or has broken into my car?
It would qualify as an entering auto.
So you're not saying that my client is lying about the person being in his Escalade, you're quibbling with the legal definition of how he described it.
I'm gonna object to the characterization of the question because he never indicated anybody was lying. That's added by.
You can continue to pursue this topic, but it's inappropriate to ask one witness to say, are you saying another witness is lying? You can highlight conflicts in testimony to.
Other witness. I was talking about the same witness.
No, your question was, are you saying that my client was lying? And that's an improper question. Your line of questioning is proper and you may continue it. Let's not ask people, are you saying person X was lying?
Are you necessarily being combative and argumentative and obstructionist with me when I am simply trying to ascertain, did Cordarius Skelton enter into my client's Escalade, get caught in there, and a fight ensued, resulting in his brother calling 911?
I think that was the question.
Do you doubt that that happened?
I have no doubt that that the decedent in this case may have pulled on the door and entered the car. And to the statement of your client, there was a physical assault that did occur.
In the driveway where you found the blood, correct?
In front of the residence. I'm not going to specify exactly where, but in front of the residence, yes.
Did you look for blood on the property of 516 Chapel Road as part of your homicide investigation as the lead detective?
We did, yes.
You instructed crime technicians where to take photographs at the 516 Chapel Road address, correct?
Correct.
You were the supervisor of the various moving parts.
I was not the supervisor.
You were the one coordinating everybody.
Yes, the scene was processed in my direction, yes.
Did you direct anybody to process any area of the grass in front of the residence at 516 Chapel Road?
I don't believe so.
And that would be because there was no potential evidence in the grass in front of 516 Chapel Road, correct?
No. When you are processing for evidence, you are processing for things that are visible to you. I processed and we had identified the blood that was visible to us at the time. There was no visible blood that we had seen on the grass. Thus, we didn't have the crime scene techs go through every blade of grass and see if there was blood there.
Did you see any blood or other indications of a struggle on the area of the intersection of the sidewalk and the edge of the grass?
No.
So where the grass meets the sidewalk, did you see any disturbance, any boot marks, any scuff marks, any blood, anything whatsoever to indicate there had been a struggle?
Are you asking me if I observed Footprints or boot marks in grass?
No, I'm asking you what I just asked.
Why don't you ask again? Try to condense it a little.
We'll take it step by step. Did you see any disturbance in the grass indicative of there having been a struggle in the grass?
No,
Did you see any disturbance of the area where the grass connects with the sidewalk, indicating that there had been a struggle in the area where the grass connects to the sidewalk in front of the house?
no,
Did you see any evidence on the sidewalk itself, from the street to the grass, the entire width of the sidewalk in front of the house? Did you see any evidence whatsoever of any struggle in that area?
no, sir, not that I recall.
And if you did see it, you would have documented, correct?
Correct.
And you know you didn't see it, you didn't document it.
I'm not sure what you're insinuating,
Just
but
one time for each question, please.
The blood that you saw on the sidewalk was the entire area of the blood photograph?
you're referencing the sidewalk. I'm referencing the blood that was observed on the property of 516 Chapel.
In the driveway?
If my recollection serves me well, it was in the driveway and on the front porch of 516 Chapel.
Did you direct someone to take photographs of the blood?
Yes,
Did you direct someone to take samples of the blood?
yes,
And at some point, you would try to determine, obviously, whose blood it is, correct?
I did.
Did you find any blood on Bliss Street?
No, sir.
If one is walking, running, or being dragged, or being carried, or being pushed from 516 Chapel Road to the area where the body of Cornelius Skelton was found, would you have expected to have seen evidence of that sort of transportation?
So respectfully, I'm not a crime scene expert. I'm not a ballistic expert. I'm not a medical professional. I can't speak to how blood is transferred from a person walking, running, or moving. That's out of my purview of my knowledge, sir.
Did you find any evidence on Bliss Drive of anything noteworthy happening in this case?
I don't believe so, no, sir.
Did you find anything at the house between where the body was ultimately found on the same side of the street before you get to my client's father's house, the him and hers location? Did you find any evidence at that location?
You're referring to him and hers, which is the property, the closed property that is directly next to 516 Chapel, correct?
Correct.
No, we did not find anything, sir, no.
Did you look?
Yes,
Who looked?
all of us.
Any documentation of you looking?
I mean, you can watch Vatican footage and watch people walk around, but in order to get to 516, you gotta, and you're on a word, sir, you gotta walk through Bliss. So if you walk through Bliss, you have to look at that address there, the him and hers store that is closed. Nothing was observed, nothing was found.
When you were looking for blood, was it a eye-only examination, or did you have cameras and officers with you with body cam footage and flashlights, infrared cameras, something to indicate more readily to the human eye that there may be blood?
So I believe you may fall into the same boat of some others that think this is like a CSI episode. It doesn't necessarily happen like that. It is what we can see visible to the human eye. And what was visible to the human eye has been documented in crime scene photographs and audio and video evidence and been submitted to this court.
You have access upon request to infrared cameras, don't you?
I'm not sure, sir.
Have you ever processed a homicide indoors where you're seeking to see if there's blood on the walls?
I don't object to relevance.
What's the relevance of a scenario of an indoor homicide, given the record that's been established here?
The witness has alleged that CSI episodes is what I am referring to. The witness has said he doesn't have access to other types of readily available machinery to have illustrated more readily the presence of blood. My purpose is to indicate he's wrong and to go through the times when he has himself utilized those particular items.
Okay, you can go a little further if you ask your questions only once.
Have you sought to look for the presence of blood using any machine in the past?
No, sir.
Did you see any disturbance on the grass or dirt or weeds or bushes between Bliss Drive and where the body of Cordarius Skelton ultimately lie? Any disturbance indicating that a body had been dragged there through?
Specifically in the wooded area, I'm not the wooded area, in the grassy area in the field, there was blood, a blood trail that went to where the body was discovered, yes.
Where was that?
Somewhere in the field.
Did you document it?
All items of evidentiary value were documented by crime scene technicians via photo. Yes, sir.
Are you referring to the blood immediately surrounding the body?
I'm referring to the blood that was observed by the decedent and by where his property was discovered. Yes.
There's blood where the body was. How the body got there, that's where my question is directed. Any indication to you, not from immediately where the body was, but there are coordinates leading away from the body? Did the body come from the left, right, east, south? Was there a disturbance indicating the direction of travel?
By disturbance, what are you referencing specific? I need you to be a little bit more specific by what you mean by disturbance.
I'm going to say any disturbance indicating the direction of travel.
And ask again, what do you mean by disturbance? Are you talking about a footprint? Are you talking about?
Don't talk over each other. Let him finish his question of clarification. And if you want to answer it, I know you're the one asking the questions, but I'm going to let him finish.
My question of clarification is simply, what do you mean by disturbance, sir?
Mr. Bass, let him finish.
I'm
I'm going to let him finish saying what he's going to say before you start talking again. You don't have to answer it, but he's entitled to finish what he's saying before you talk over him. Do you want to say anything else, Detective?
Yes, sir. So I'm simply trying to understand, what do you mean by disturbance?
And I think I'm gonna leave it for the jury to ascertain your testimony.
Okay.
All right. Any redirect?
Very briefly. Detective Stansel, the interview that you did with Mr. Saul, did that occur at his home?
Yes.
And did you actually go to or in his home?
The interview occurred outside of his home. I believe it was a greenhouse. Like I said, that was my mistake. I got the numbers mixed up. That's my fault.
Numbers, color, or whatever it may be, the home that you knew to be Mr. Saul's, did it have a direct view across the street to 516 Chapel Road?
Yes, as I referenced earlier, it should be noted that the red houses on the odd side, I guess on the right side of going north, are angled. So you do have a direct line of sight to 516 Chapel. You can see 516 Chapel, and you can also see the gas station down the street.
And is, in your opinion, and based on your training and experience, is recording interviews, whether it be with a recorder or with body cam or some sort of video equipment, a form of memorializing your investigation or the conversation?
Yes.
And can you tell the jurors, during your interview with the defendant, didn't he tell you he beat up Cordarius Skelton?
Yes.
During your interview with the defendant, didn't he tell you he took Mr. Skelton's body down to the field?
Yes.
No further questions.
Mr. Bass, any recross?
Yes. The figures that you tried to point out, how tall are they?
I'm not sure.
What gender?
I'm not sure.
What race?
Not sure.
Age?
Not sure.
Did they proceed straight down Chapel or make the right on Bliss?
I believe I've already answered that, and it was not seen in the video.
What time did my client leave that morning in his Escalade?
I believe I answered that question as well, and I advised you I did not know.
When my client left, how many occupants were still in the house?
I don't know, sir.
Nothing further.
Jurors, questions for the detective? You're a popular man.
In the air.
Is there a reason why you fold the card up? No more folding. All right, you all can be at ease for a hot minute while we go through these, and we'll be back. Counsel?
Oh, you go first this time. No, you went first last time.
Go. Detective Stansel, you've described blood found out in the field where the deceased was found and blood on the porch and steps area.
Yes.
Was blood found anywhere else outside 516 during the course of your investigation?
No, sir. Specifically, the blood was found at 516, and it was found in the area in the field in which the decedent was located.
Okay. Was any of the blood that was on the front steps or the porch, or whatever we're going to call it?
I do apologize. I should note that I did locate blood inside the residence.
I don't want to talk about inside the residence, specifically outside the residence. The blood that was found outside the residence, was it collected, or were samples of it collected?
Yes, sir, it was.
Okay. And do you know what happened with those samples?
I believe the crime scene techs took the samples and those were submitted to the GBI.
Okay. You were not involved with any testing of the blood?
No, sir, I'm not, that's out of my purview of expertise, sir.
Okay. Did you ever end up getting a statement from either Mr. Freeman Sr. or Mr. Freeman Jr.?
No, sir.
The occupants of the house that would be described as most directly across from 516, whatever number that is, it sounds like you did have an interaction with them.
Yes.
Can you share with the jury if they said they saw nothing or heard nothing, or what was the gist of what they said?
No problem. To be blunt, it was an older African-American woman who seemed a bit senile. She literally spoke to us through the window, and she's very dodgy about everything. I don't know what y'all doing here, da, da, da. So it became one of those situations where we're like, okay, clearly talking to you is not gonna help us here, because not only are you not really wanting to talk to us, but kind of your recollection of things may not be is, where it needs to be.
Did you ever develop any information about where Mr. Freeman Sr. and Mr. Freeman Jr. were at the time the search warrant was executed at 516? Because it sounds like there was only one occupant at the time, Ms. Davis.
Correct, sir. There was only one occupant at the time. I did do a search warrant for the phones and location data. From that, it did.
So I don't want you to get into contents of something that's not in evidence, but did you seek to determine where Junior and Senior were?
I did, and my attempt was to make contact with them, but once again, all attempts were failed at the time.
Okay. At any time during your interaction with Ms. Davis, did you tell her that she was going to be charged with anything?
No, sir.
Did you ever determine if Mr. Dennis actually went to work on February 5th, 2024?
I did not.
Was his Escalade ever searched or inventoried?
Yes, it was, sir. The day he was arrested, the vehicle was searched and inventory. Yes, it was.
Reference the video footage from the gas station. You were describing seeing two figures walking back up the hill after what you described as a muzzle flash. So emphasis on two. You described seeing two walking back up the hill. Tell the jurors how many people you observed going into the field before the muzzle flash?
Based on what I was viewing, I believe I saw two people going down. But like I said, it's not super visible, given the fact that it's only becomes illuminated via the light. But like I said, based on witness statements, we corroborated what the video footage showed.
Got it. Mr. Abadi, anything else for Detective Stansel? Mr. Bass?
One moment. Nothing further.
Detective Stansel, thank you for your time.
Thank you, sir.
You are free to go. You can leave all those things right there. Mr. Abadi, next witness.
I have a witness and some documents that I need to introduce them to evidence.
Okay. We may have a stipulation. Anything beyond that?
Yes, Your Honor. State would tender with regard to State Exhibit 1, which is a certified conviction for the defendant, Brett Dennis, out of the 15th Judicial Circuit of Palm Beach County. Case number 2021 CF 001672
Okay. Mr. Bass, do you have any objection to the admission of States 1, which is a certified copy of the conviction of your client in Florida a few years ago?
No.
Okay, it's admitted. And then other than the stipulation, which we need to talk about during the lunch break, anything else from the state? So at this time, the state rests?
Yes, Your Honor.
All right. Ladies and gentlemen, we're going to take a break for lunch. And I'm going to ask you all, you've now had a couple lunches here, maybe. We've had one and then we didn't really do lunch yesterday. If we try to keep it to like 45 minutes, does that give you enough time to eat, or is that cruel and unusual? It's close. Will you go really far away or you chew slowly? Okay. Why don't we make it 50 minutes and let's try to be back. That clock is at about 12:30. Let's try being back at 1:15, 1:20. I'm not going to fuss if at 1:17 not everyone is back, okay? And we will get rolling. The lawyers and I are going to work through some things during your lunch break, and we will see you back here 1:15, 1:20, okay? Please, what is important, even though the state has rested, it's not time to start talking about the case. The defense has a right to present evidence if they want to, no burden, they may not. But the defense hasn't rested yet. You haven't heard closing arguments. You don't have the law that you must apply. So enjoy lunch. Don't talk about the case. No outside research. We'll see you in about 47 minutes.
All right, very good.
All right, you all can be seated. Let's talk about the stipulation first, and then Mr. Bass, I'll ask you if you have any motions. And then we need to talk a little bit about your presentation and whether Mr. Dennis is going to testify or not.
If you would, my client is a little agitated because I have this Detective Stansel's APD record with prior reprimands and suspensions. I chose tactically not to go into it because I think it was obvious to the jury that he was being evasive with me. I had already pointed out the inconsistencies in his recitation of the address of Mr. Jaime's not being across the street, as he said, further down. So I figured I had established that he is being combative with me. I didn't see the tactical need to go into the fact that he had previously been reprimanded with what I understand was incomplete reports and failure to record items that should have been recorded. My client disagrees. I wanted to object on the record to me not going into that, he believing that being a violation of his 14th Amendment rights. So he feels he has not gotten a fair trial because of my decision not to pursue that line of, that avenue with Detective Stansel. So I'm putting on the record what my client wants on the record, understanding that he can't talk and put on the record his own items, but I can put on the record what he wants me put on the record.
Okay. Well, I want to note that you, Mr. Bass, are an experienced litigator. You are an effective litigator. You are the subject matter expert in this space as to what makes for a successful and effective cross-examination. And it is 100% your decision and not your client's as to how a cross-examination is conducted. Your client will be free, should he be found guilty, and we don't know what's going to happen at the end of the trial, to raise his concerns about your performance through his appellate counsel. Of course, if he's found not guilty, then he owes you an apology because you would have demonstrated your efficacy, to use a word you've liked to use during this trial. So I appreciate you, I guess, putting it on the record. It's really not relevant to what we're doing. And that's not that I don't care what Mr. Dennis thinks. I want him to feel like he's getting a fair hearing. But he needs to accept the fact that despite him telling all of us through his interview that he studied the judiciary and his repeated references to the 14th Amendment, which really doesn't apply right here, what is very clear is that it's your professional judgment that comes into play. I have no questions about your professional judgment, but I guess for Mr. Dennis's sake, you've made a record of what you decided and the fact that he disagrees with it. Now, Mr. Dennis, the one thing you could do if you want to right now is tell me you are firing your lawyer and that from here forward, you want to represent yourself. I wouldn't make Mr. Bass leave. He could sit by your side. But unless you are telling me you want to fire your lawyer, he makes the kind of decisions that have frustrated you. And if you believe that you're correct, that there was some 14th Amendment violation, and that impacts these proceedings, and you're found guilty, you or a lawyer appointed to represent you or one that you hire, if you choose to hire one, will be able to make that argument, not just to me, but if I don't get it, I mess it up, to a higher court that Mr. Bass was deficient in his performance when he elected not to try to impeach the detective with the detective's history on the police force. Okay? Mr. Bass, anything else?
No.
All right. Can we talk about the stipulation now?
Yes.
All right. Can you take your picture down?
Oh.
Thank you.
That's what you say to the Court of Appeals. That's an argument that you make.
So Mr. Abate shared a proposed stipulation via email. I actually have already done one based on the previous trial. So if you look on the screen now, I think it should be visible. I'm happy to print this out if upon reading it, both sides agree that this stipulation addresses count 10. This is all about what constitutes a qualifying felony. And this may look a whole lot like what you sent, Mr. Abadi. I just didn't have a chance to look at yours yet. Okay. Probably because I borrowed from whether you did it or Ms. Wood in the Mosley trial. Okay. Mr. Abadi, have you had a chance to look at this proposed stipulation?
Yeah, it works for the same.
Okay. Mr. Bass, have you and Mr. Dennis been able to move past Detective Stansel and get to the matter at hand, which is this proposed stipulation?
We have both read the stipulation. I agree to it. My client does not.
So, Mr. Dennis, I want to make sure you understand this. If you do not stipulate to the fact of your conviction in this way, because you're not required to, then the state will be allowed to, they've already entered into evidence, but the jury won't see it, your Florida conviction. Well, here are your two choices. And you can preserve, if Mr. Bass thinks it's a valid, non-frivolous argument to make, he can say it's a 14th Amendment violation. But here's the crossroads right now. Either the conviction that is in the record, but the jury will never see, goes back with the jury. So the actual conviction, it states one, all that paperwork from Florida about your gun conviction from 2022, that will become part of the evidence the jury can see. That's option one. Mr. Bass has asked that that not be what happens, because then the jurors see the substance of the conviction and it involved the gun. And I can understand why Mr. Bass wouldn't want the jury to see it. And on your behalf, he has said, let's keep that out. And I can keep it out legally if there is a stipulation whereby you and your lawyer say, hey, Mr. Dennis is a convicted felon. It's really none of your business what that conviction is. That's what the stipulation does. It simply says, yes, back in Florida, in Palm Beach County, in September of 2022, Mr. Dennis was convicted of a felony, and that felony qualifies for count 10 in the indictment. If you don't want to stipulate, you don't have to, but you need to understand that if you do not stipulate, then I'm authorized by law and probably required by law to let your conviction go back with the jury. So you may not like the two options, but those are the two options. And I'm pretty confident legally I'm correct in presenting with you with those two options. I'm hearing you that somehow that makes your trial unfair and equal protection and all that. I'm not persuaded by that, okay? So you and I aren't having an argument. I'm just explaining you to the situation. You talk with Mr. Bass, and Mr. Bass, you let me know if Mr. Dennis wants to maintain his refusal to sign the stipulation.
Yes, let's do it.
All right, I'll print that out and everyone can sign it, and we'll get that in front of the jury when they come back. What's next then is any motion you may have now that the state has rested.
No, they set the venue with their last witness. I was hoping they wouldn't. I don't have any motions.
Okay. Then, Mr. Dennis, you and I need to have the conversation I previewed with you yesterday, which is about your right to testify and your equal right to not testify. You ready to have that conversation?
No, I get the right.
When you're done with the jokes, let me know if you're ready to have the conversation.
Yeah, absolutely serious, sir.
Okay. Mr. Dennis, do you understand that you have a right to testify and that if you want to testify, no one can prevent you from doing so?
Exactly, absolutely.
Do you understand that in the same way, no one can compel you to testify, meaning you have a right to remain silent if that's what you wish to do?
Absolutely.
Do you understand that you and not Mr. Bass will be telling me in a few moments whether you want to testify or not?
Absolutely.
You're very absolute about things. Do you understand that if you do not testify, I will tell the jury in my instructions to them that they cannot hold that against you in any way?
Absolutely.
Do you understand that if you choose to testify, you will be examined not only by Mr. Bass, which generally will be the easier questions, but also by one of the two prosecutors?
Absolutely.
You don't get to invoke your fifth and say, I'm done answering questions. I don't want to answer any more questions. You understand that?
Absolutely.
Okay, good. Knowing those things, absolutely, Mr. Dennis, do you want to testify in your case?
Yeah.
Excellent. I will let the jury know when I am charging them that in conjunction with me telling them, again, there's no burden on the defense, that they are to consider in no way whatsoever the fact that you did not testify. The last thing I'd like to do is go over the draft charge. Do you guys want to break first and come back and do that? Or do you want to do that and then break?
I think it would be benefit, are we going straight into closings?
So here's a dilemma we've got timing wise. I think I have to break at around 2. And I was hoping lunch would be sooner, but we needed to finish Stansel. It didn't make sense to interrupt that. And we wanted both sides to get all the way through. So we would go straight into closings. I just don't know how far through the first closing we'll get. So that's.
I intend to reserve.
Okay, so the first closing would be Mr. Bass. Mr. Bass, how long do you envision your closing being?
3 days.
All right, well then I don't feel bad if we have to interrupt it a few minutes in. You know what, I won't even press you on that.
30 minutes.
Okay. We may break a little later than 2 so you can get all the way through your closing, and then that'll be the natural break point. So what I'd like to do is we're gonna have a quick charge conference now, and then we'll take a break and get rolling. So I'm gonna put on the screen that which I sent you last night. I think it is, let's stop the share. There. Okay, on the screen is what was emailed last night. I'm going to scroll down to areas where I had questions, and if I skip over something that you had a question or concern about, let me know. I will unhighlight the language on page 3 now that we know we've got the stipulation. And then the stipulation charge will go in there at the bottom of page 3. And then on page 5, I will give the law about a defendant choosing not to testify. So they will hear that. And I think that's it for questions I had about should it go in or not go in. So let me turn to you, Mr. Rao, as the closer. Did you have any additions to this proposed charge or omissions you wanted?
Not that not for my review.
Okay, Mr. Bass, same question.
I'd like a lesser included of battery.
So talk to me about that, given that the aggravated assault that's alleged isn't the facial injuries, it's the shooting. I'll tell you this, I had the same thought when you were talking with the detective about, did you see evidence of battery? I think if the state had charged Mr. Dennis with a second aggravated assault count for beating with hands and fists or whatever, a battery charge would be appropriate. But the language of the aggravated assault charge is that Mr. Dennis assaulted Mr. Skelton by shooting him with a firearm. And the only evidence that the jury has of gunshot wounds were fatal gunshot wounds to the head. And I don't think there is evidence that would properly categorize those as battery. I think in addition to that aggravated assault, there's conduct that could have been charged, as I said, a second aggravated assault or as a lesser included battery. But I can't think of a charge that would appropriately be reduced to battery that has been charged in the indictment.
Understood.
Okay, so you've made the request, I'm denying it, so you've preserved it. If on review a court says that should have been given, that's reversible error, my mistake. Anything else, Mr. Bass?
No.
Okay, then why don't we take our part of the lunch break? If you're gonna be using technology, then you should have it set up, before we bring the jury out, so that you're good to go. If not, you're ready. So let's be back here, at 1:15 on, the clock in here, so half hour. All right, thank you. Mr. Bass, since you're wandering, can you come up here, please? And get a few things. One of these is for you, one is for Mr. Rao. Wait, don't leave. This is the stipulation that you and Mr. Dennis, and I put Mr. Body's name on it. He needs to sign it. And wait, one more. The verdict form that I need you all to look at and say that works or doesn't work.
Want me to save time, fill it out now? Very full.
Now I'll leave that to foreperson. Thank you for offering.
One copy.
Did you look at it, Mr. Vance?
You don't have to call me Mr. Bass, call me sir.
Man, what the-
Look at that, you're gonna give me that. Go ahead, ask for extra, anything else, complicated. Better for the environment, we do a 2 count this thing.
Thank you. If you could, during one of the 2 closings, just make sure all the evidence is in order, then we can have that quicker conversation of what goes back and what doesn't. Are they good to go?
Yeah.
Okay. When you're ready, if we can bring Mr. Dennis out, please. You always do a good job appointing. It's a good delegation.
The house is too, yeah, food trucks outside Price Street.
So they were supposed to do that Grub and Groove, but it got canceled. So maybe they have food truck. They blocked Prior Street? Oh, or just a bunch of trees there, trucks there. You went out there?
Yeah, I went out to go see, but the house was.
Oh, crazy lines.
It really was a lot of people out there.
All right, can I have the verdict? I have it.
Yeah.
Great. I need that. And do you have the stipulation? Okay.
Carries 15 years to 11%. Yeah, but none of the stuff I said goes to the what I was talking about that.
All right, Ms. Rivers, let's get back on the record, please. We are continuing with the trial of State versus Dennis. Mr. Dennis is in court with his lawyer. We have our prosecutors here. Our jurors are ready to go. I want to share with you all one change I made to the jury charge. If you would turn, you should each have, both sides should have a hard copy of the charge. And I added one charge that I think is appropriate. If you'll turn to page 5, there is now language about statement of the defendant. Neither side asked for it, but the jury has a statement of Mr. Dennis. So I believe it's appropriate to include that language in there. I don't know which one of you on the state side has a hard copy of the charge. Any objection to including language about the statement of a defendant? Okay, Mr. Bass?
No objection.
Okay, so the charge is good to go. You guys have copies of that. Mr. Bass, did you have an opportunity to look at the verdict form?
I did, and do not object.
And Mr. Abadi?
No.
All right, and then that leaves the stipulation. Mr. Bass, have you and your client signed the stipulation?
Can I see the verdict form?
Sure. Thank you. I'm gonna give it back to you if you want to put an evidence sticker on it, and you can tender that once the jury comes back in.
Would be a court's exhibit, Judge, or do you want it to be labeled as a state's exhibit?
We can call it a court's exhibit because it's not one side stipulation or the other. So why don't we do that? You can give it to me after all, and it'll just be something that goes back with the jury along with the indictment and the verdict form, et cetera. Can you work on a redacted version of the indictment that doesn't list the specifics of the conviction? That'd be great. All right, Mr. Bass, do you still, no, I have the verdict form back. Anything we need to cover before the jury comes back in?
No.
Okay, Mr. Rao, anything before the jury comes back in? So when they come in, I will let them know that there's a stipulation. I'll read the stipulation into the record, and it will become part of the record. And then, Mr. Bass, I'm going to ask you to call your first witness. You'll say, I think, the defense rests, and then I'll let them know the evidence is closed, and you'll be able to move straight into your closing.
Understood.
Excellent. Let's do it.
All right, I'm there.
Oh, no. Go where you want. I don't go where you want. That means you will.
Thank you, Deputy Gordon. Everyone can be seated. Welcome back from lunch. I hope you all had enough time. I appreciate you being prompt. When we broke, the state had rested. There's one more piece of evidence that I'm going to put into the record. You'll have what I'm about to read with you during your deliberations, and then I'm going to turn to Mr. Bass to see if the defense is electing to put on any evidence. And what I'm about to read into the record is a stipulation when the two sides agree to certain facts. And what I'll instruct you at the end of the trial is that you're to accept those facts as evidence without the requirement of further proof. The parties to this case stipulate to the following facts. Brenton Dennis was convicted of a felony on September 13th, 2022 on information number 2021 CF 001672 AMB in the Circuit Court of Palm Beach in Florida. Thus, on February 5, 2024, Brenton Dennis was a convicted felon. And finally, this felony conviction from Florida is a qualifying felony as required for count 10 of the indictment. And when I'm giving you the elements of the crimes, you're going to understand what this qualifying felony piece means. It's an element of count 10 of the indictment. And the parties all stipulate to that as of today. With that in, Mr. Bass, if you will call your first witness, please.
The state defense arrest. Defense arrest.
Okay, so both sides have rested, which means, ladies and gentlemen, the record is complete. You have received all the evidence that you're going to receive. Two parts remain. One that we're going to get into right away is closing arguments. This is when the lawyers get back in front of you to argue their case, to seek to convince you to decide the case in one direction or the other. Feel free to be persuaded by the lawyers, but keep in mind that what they say the evidence is not what controls. You decide what the facts are in this case based on the testimony you've heard and the exhibits that have been admitted. When the lawyers are done, then I'll give you the law that you must apply, and then your deliberations begin. The state has the burden of proof in this case, as I've told you several times, which means they have the opportunity to open with closings. In other words, get up and talk to you first, sit back down, have Mr. Bass go, if Mr. Bass wants to give a closing, he doesn't have to, and then the state can have the final word. They can also waive that first part and just reserve everything till the end. Mr. Rao, what is the state's election?
State likes to reserve, Your Honor.
Okay, Mr. Bass, that means you, sir, are up.
Thank you, Judge. In the 16th century, there was a political treatise called The Prince, written by Niccolo Machiavelli. It was subversive. It was banned for a while by the Catholic Church. The essence of the treatise was to give information, instruction on how to rule, how to govern, how to be a true prince. It was ruthless. It was immoral. Machiavelli attempted to be purely factual. What's the best thing to do if you want to get and maintain power? He goes into different avenues throughout his work. You have to be a lion and a fox. Lion, you have to know when to attack. Fox, you got to know when to lay back and be cunning. There were a lot of tactics in the work. For purposes here, there was a reference to the ends justifying the means. Is where that phrase is thought to have been coined. The ends justify the means. If you believe something strongly enough, it doesn't matter what you do to get there. If you believe in the greater good, it doesn't matter that a few must be sacrificed to get there. If you believe that Brenton Dennis is guilty, it doesn't mean you have to talk to all the witnesses. It doesn't mean you have to present unbiased, objective, thorough, comprehensive answers to questions. You can be evasive as a detective. You can hold back evidence until the last minute. You can fail to record interviews with your witnesses. You can spring witnesses a couple days before trial. You can do all of these things because the ends justify the means. It's no longer the process that's important. It's no longer the search and pursuit of truth, honor, justice, integrity at the moment that's important. It's where you end up is where you're focused. It's not, what am I saying to this witness at this point in time? What am I telling defense counsel? What am I telling the judge, the jury? That's important. It's how do I get the conviction I want is where I'm focused. Not I'm going to be righteous in my investigation, truthful in all things I do and wearing the uniform, and hope that at the end of the day, justice prevails. No, I'm going to put my foot on the scale. I'm going to say across the street where I know the witness wasn't across the street, but was down the street. I'm going to say the witness walked toward a certain house, ignoring all the other houses in between and the street that intersects. In this case, the prosecution was acting as a student of Machiavelli, that the ends justify the means. You will hear from the judge once the prosecutor finishes their closing what the jury instructions are. You've heard the evidence. How do you apply the evidence? What law, what are the rules in your deliberation? You're going to hear one thing that is critically important. It is not enough that you have a grave suspicion that Britton Dennis did anything. You have a grave suspicion is not enough. Every single material allegation must be proven beyond a reasonable doubt. If any material allegation is not proven, you do not have an option. You must find the defendant not guilty of that offense. The ends do not justify the means. Additionally, burden of proof. You've heard ADA Abadi say during the course of the trial, defense counsel could have done this. Defense counsel could have done that. Defense counsel could have shown you this. Defense counsel could have shown you that. Brenton Dennis has zero obligation in this case. The burden of proving the case lies 100% with the state. If they fail to show a connection to a weapon, they fail. If they fail to show who fired a shot, they failed. If they fail to show where the crime was committed, they failed. If they fail to show who committed it, they failed. I, Mr. Dennis, have zero burden. It's with the state. Witnesses, are they credible? Are they not credible? You are to rely upon your collective experiences, the wisdom that you've accumulated over the years in discerning when somebody is lying and looking at posture and looking at a person's eye contact. Is the voice inflection changing? The probability of what they could say, the inconsistencies in how they're saying it, and judging, is what they say worthy of belief? One of the key components in determining is a witness credible is looking at inconsistencies that may have existed in their testimony. Did they say at one point this? We can take it from here. Are they saying it in a different manner? Are there things that cause red flags to go off? The more red flags, the less credible. Bias, motive. Why might a person change their story? Is there a new girlfriend on the scene now that wasn't before? Why might a person change their story? The first witness was Jason Teague. He told you he simply pulled the footage as directed. Kind of mindless wandering around, not thinking on his own. He just did as the lead detective told him. He said, pull the footage from the side of the Exxon service station. Other footage could have been pulled from inside, didn't bother to think for himself. Other footage could have been pulled from the front of the store. Did the black Escalade leave the house before the shooting? Possibly would have known if we had the camera footage to show it at the pump, the gas station. Not available. Why? It existed. We know that because the other footage existed. Officer Teague told you himself, I didn't even bother to look at it. In a homicide investigation, didn't bother to look at it. Then James Campbell called 911, the second 911 call to report shots that had been fired. 6:38, over a half hour after the first 911 call. 6:38, James Campbell told you under oath about his personal knowledge of drug activity in the area, of cars parked at the Exxon service station, about mules walking up and down the street. His own testimony, not mine, not the state's, but their witness told you under oath there was a reason why police had been called to that area previously. Shots fired were not unusual, unfortunately, in that area. James Campbell told you that. On this day, he called, but on other days, he had heard shots. Did he know who fired the shot? No. Did he know who had been shot? No. But it's not that significant. We know somebody was shot. This is not a what happened. This is a whodunit. We know Cordarius Skelton was killed by a shot to the head. That has never been in doubt. What we do know is that one gun shot him. Unless, for some bizarre reason, somebody shot him and then decided to hand the gun to the second person to fire the second shot, which is unbelievably absurd. We would have to assume, based upon our knowledge and rationality, that one person fired both shots. Campbell testified the shots were close together. One person fired both shots. Both shots were near the same area of the body. One person fired both shots. Who fired the shots? That's the question we have to determine. Johnny Wynn testified at 6:38 when he arrived, it was very dark. Why is that important? You have people saying they see things in an area where there's no evidence to corroborate what they say they saw. You have a person saying, I see in the bedroom of the house a fight in the grass in the dark, where there's no evidence of there having been a fight in the grass in front of the house. None whatsoever. You have not seen one shred of evidence about there being a fight where the fight was claimed to have occurred. In front of the house, in the grass, by the street. No blood. Where's the photographs? You've seen a lot of photographs. Some gruesome, a lot of photographs, but no photographs of blood in the area where the fight was alleged to have occurred. None. Saul Jaimes lives at 503 Chapel Road. 503. We have heard, my client and I, in preparation for his defense, 511, preliminary hearing, 511. Discovery, 511. All aspects, 511. Witness statement from the owner of the house across the street. Saul Jaimes. It's wrong. It's incorrect. It's inaccurate. Why? Because according to the detective, the ends justify the means. I'm going to say that the person across the street saw something to get them closer to the area of the guy I want to convict. I'm not going to tell the truth and say 503 down the street, 516, 513 across the street, then 511, then 509, then 507, then 505, then 503. But we're to believe that was across the street. In the dark, he can make out credibly what he claims to have seen. Adrian Pitts responded and recognized Cordarius Skelton. He knew him. Then comes Detective Churchill with the canine, looking for shell casings and evidence of the gun. Never found casings. To this point in time, we have not had any evidence introduced by the state as to the ballistics match on any gun. Non-existent. Non-existent. None. A witness testifies there's a small gun seen. No gun is ever produced at this trial. None. No connection to the defendant whatsoever. None. Crime scene technician Sharon Davis knew when she was at the 516 Chapel Road address that she was the point person to prosecute and provide evidence in a homicide investigation. That ought to have raised her attention to detail in what she was doing. A crime scene technician looking for blood does not take any photographs of the grass where Chastity claims she saw a struggle. No disruption in the grass. We saw how, unfortunately, Mr. Skelton was beat up. We know that wasn't just falling down. That was a pretty good fight. He got hit a few times. He got bloody. He got cut. That's a fact. But it's also a fact that he's not charged, my client, with that at all. He is not charged with battery in this case. He is not charged with going too far, getting the guy out of his car whatsoever. That's not a charge. It could have been. The state could have said there's a battery or aggravated assault because you beat the guy. You used a weapon or something on the driveway. We know the fight was on the driveway, obviously, because of the blood was. Blood didn't bounce from the grass to the driveway. The fight was in the driveway after the guy got pulled out of the car. Common sense. And my client was so angry that Skelton was caught breaking into his car that he shot him point blank in the driveway. No, that didn't happen. Nothing like that happened. How do we know? Because we heard the 911 call. The guy's coming out of the truck. He confronts them. They start fighting. His little brother's on scene. On the phone, we heard the 911 call. He tried to do the right thing and call police. Did he take the law into his own hands? No. He calls 911. His brother's on the phone speaking. And who do we never hear on that 911 tape? We never hear Chastity. She claims to have come outside, walked down the steps, and was told to go back in by Timothy, my client's brother. We hear the call. We hear my client in the background. We hear the scuffling. But we know that that was never said, because if it was, it would be on that call. Chastity lied. Why? I don't know. But through the process of analyzing her testimony, use the tools you're provided with. One of the tools is analyzing bias and motive. She stayed in the house for months. If you're scared, you leave. Right now, she claims to be living with friends in between friends. Why couldn't she have done that then? Her parents were here. Her father and her brother were here in court when she testified. She could have gone home. She could have left. But no, she was so scared she stayed. She was so scared she was putting money on my client's books at the jail. She was so scared that she continued to call my client. It makes no sense. Everything changed though when she was replaced. My client's new girlfriend.
The
or
objective
fiancée,
of this characterization of the evidence has actually been zero evidence that
Let's limit ourselves to evidence that's presented to the jury as opposed to people sitting in the gallery.
Chastity never told you what time Brenton Dennis left or where he went when he left. If something is possible, then you can't say beyond a reasonable doubt it didn't happen. Is it possible Brenton Dennis, when he left the house, got into his truck and went to work? Is it possible? We have no evidence to the contrary. None. We know there were 4 people in the house. 4. Nobody can tell the gender, the race, the height, the weight of anybody allegedly identified by the detective. You'll be able to look at the video yourself. When the state put the image of the .38 slug on the screen, did they have to point to the slug? No. When they put the photographs of the house on the screen, did they have to point to the house? No. When they put the photograph of the body of Cordelia Skelton on the screen, did they have to point to the body? No. Why did the detective have to draw your attention to images on the screen? Because you can't tell what you're looking at. He's trying to corrupt your understanding of what's in the screen. You don't tell somebody what they're looking at. You show them and let them make up their own mind. Just like when you have a witness come to your office, you don't show them a bunch of revolvers and ask them to identify one, trying to corrupt what they say. You ask them what you saw, what did it look like, what color it is, can you draw it, what did the handle look like, how long was the barrel, and then you get somewhat of an understanding in their own words, and you can develop a target package of possible guns based upon that, rather than show them something to lead them down a certain way. The defendant's father, brother, walking down the street. We don't know. The defendant and his brother walking down the street. We don't know. The defendant and his father walking down the street. We don't know. The defendant and Chastity walking down the street. We don't know. Chastity and the little brother walking down the street. We don't know. Chastity and the father walking down the street. We don't know. Who are the people in the images? Or did they come from Bliss Drive that the detective never bothered to check? Never bothered to mention? Just steps over Bliss Drive to get to the means, the end. Never interviewed the people in the house with a straight shot, a straight vision of the field. And then he's going to try this convoluted excuse from this, oh, they were looking through branches and the like. Every witness was looking through branches and had obstructed views, but it was never an issue till my questioning. understood every word of what the prosecution asked him. But apparently walking a straight line is something he needs clarification on. When you look at the pictures of Cordarius Skelton, and I apologize, it's going to be unpleasant. There's no way around it. But one thing is factually true. There are a lot of healed wounds. It was a rough life. He's bruised and scarred all over his body. That have nothing to do with this case. Nothing. And the wounds from the beating he got when caught trying to break into my client's truck kept bleeding when he was in the field. There's a lot of blood on his face. But when you look at the photographs from the medical examiner's office, you can see where that blood came from. You can see the cut on the cheek. You can see the cut on the lip. So you know the blood is continuing to flow as he's lying in the field. It looks bad when photographed, but there's a reason. He hadn't yet died. His heart was still beating. And when your heart is bleeding and you have open wounds, they continue to bleed. And that's what was happening. He was not killed at 516 Chapel Road. He was killed at the field. He was not drugged down the street. There is no evidence in this case of Cordarius Skelton being drugged anywhere. Not on the street, not on the sidewalk, not on Bliss Drive. There's no disturbance of the grass. There's no grass marks on the feet. There's no particulate matter in his knees that would have been embedded in his knees as he's being dragged. None of that. There's no striations in the wound consistent with being dragged. If you're dragging somebody with an open wound, you're going to see these literal lineal striations in the wound. That's common sense. But none of that appears. You'll see gravel in the wound where he fell in the dirt if he was drugged down the street and across Bliss Drive. It didn't happen. Where's the blood trail that Adrian Pitts said he saw? He said he saw a blood trail. There is no blood trail. There's no evidence of a blood trail. There's blood around the body, and there's blood at 516 where my client was striking and being struck back by Cordarius Skelton. Did anyone analyze my client to see the bruising on his body? No. He still would have had bruising the next day. When you execute an arrest warrant, you can also do a warrant for pictures of the person's body. That's the state's investigative failure. They didn't bother to corroborate, had he been in a fight? Does he have bruising about his body as well? Just simply didn't bother to do it. They thought they had a man and they cut the investigation short. And Chastity Davis, when SWAT were knocking on her door, didn't know that somebody had been killed. There was no reason for her to avoid SWAT. She was out of it. Out of it. She took the NyQuil and she was out of it. Had the earplugs in, dogs were barking. She was out of it then, and she was out of it previous to that. Did she have a moment of clarity in her sickness, enough to see on the screen and hear things outside and walk around, and then all of a sudden get too sick to get out of bed for SWAT? No, she was sick the entire time, in bed the entire time, drugged out on NyQuil, half asleep, strep throat. Detective said he thought she was sick, too sick to have heard SWAT, but she heard gunshots down the street. No, it makes no sense. No sense whatsoever. In count one of the rather lengthy indictment, Bretton Dennis is charged with murder. A charge with ought to get the best investigation tactics employed. But apparently not. The indictment states, did unlawfully and with malice aforethought cause the death of Corterius Skelton, a human being, by shooting him with a firearm. A, we've never connected Bretton Dennis to any firearm. B, we've never tested and shown you the results of any firearm connected with the slug that killed Corterius Skelton. C, malice. You hear Bretton Dennis on the 911 call saying, send the police. Think about this. Catches the guy, and you have possibilities. Some lawful, some not. Some moral, some not. But it's decision time. You're angry. Do you go over and above and take the law into your own hands? Or do you call the police? Well, we know what choice he made because he had his little brother call the police. He hears the little brother on the phone. Oh, when I say little, it's younger, not short. On the phone, you hear his demeanor. Were they enraged, upset? No, they were trying to get the police to come out. Was this the demeanor of somebody about to commit a murder? You'll hear the tape. You can judge for yourself. They're saying, come, we're holding the guy down. We want the police to intervene. We want a lawful resolution. Because City of Atlanta does not respond to that area on a timely basis, they never show up. Count two, felony murder. The state is alleging, and everything is an allegation until you rule, that Bretton Dennis committed an aggravated assault with a deadly weapon. That rules out anything that happened at the 516 Chapel Road address. Nobody says a deadly weapon was utilized at 516 Chapel Road. There is no testimony whatsoever that the hands of Bretton Dennis striking Corterius Skelton as he was fighting back with my client was enough for you to find that a deadly weapon was used. Hands in count two are not a deadly weapon. Count three, felony murder again. Then unlawfully during the commission of a felony, committing a battery, if you feel that my client went too far at 516 Chapel, could have restrained the guy, could have hit him, or maybe hit him a few more times than he should have, that's a battery. But count three, felony murder, has to be a felony. Additionally, let me rephrase. The state has alleged that my client also falsely imprisoned Corterius Skelton. Falsely imprisoned them. Any testimony of that whatsoever? No. None whatsoever. Holding somebody, waiting for the police to come because they're caught trying to enter your car is not false imprisonment. False imprisonment, you would have to have no lawful reason to be restraining them. If you catch them breaking into your car, you do have a lawful reason to restrain them. That is not false imprisonment. Not whatsoever. So count three fails. Count four, again, felony murder. Got a lot of ink in the DA's office. Felony murder. possession of a firearm by a convicted felon, and it caused the death of Cordarius Skelton. Even if you believe, and I'm not saying it should, but even if you believe that after the fact, my client got a gun from inside his bedroom, you still don't know, did he, after having his car nearly broken into and stuff stolen, say, I'm tired of this, I'm going to work and I'm bringing a gun with me, and he left to go to work with the gun in the car? Or did he take the gun and go down the street and shoot Cordarius Skelton? Did he take the gun and give it to his brother to shoot him? Did he give it to his father to shoot him? Did he give it to Chastity? We don't know what happened. Even Chastity says she don't know what happened. So we can't beyond reasonable doubt say what happened. And we can't say if that gun, if it existed, is connected to the shooting of Cordarius Skelton. Not beyond a reasonable doubt, and a grave suspicion is not enough. Use of a firearm by a convicted felon, the next charge, causing the death of Cordarius Skelton. If at any point in time, his brother, who during winter of last year, presumably wearing a jacket, nobody knows what's in his waistband, had a gun, could he have shot Cordarius Skelton? Could someone else have shot Cordarius Skelton? Could someone at his and hers have shot Cordarius
Object to
Skelton?
this, Judge, there's no evidence that anyone. I'm gonna object to this improper argument.
So, Mr. Bass, I won't dive real deep in this, but we talked outside the presence of the jury about the necessary elements to a someone else did it defense, as opposed to there's not evidence that this person did it. And I need you to hew to the latter and not the former.
There is no evidence of what any witness on Bliss Drive saw or didn't see. And that is intentional. That was a direct decision by law enforcement in this case. Aggravated assault with a deadly weapon. Who had the weapon? The brother? Which brother? There were two. One gun, two brothers. Who had the weapon? Concealing the death of another, count 11. If you believe that Cordarius Skelton was moved, he wasn't dead when he was at 516 Chapel. You can't be concealing the death of someone who hasn't died. If they moved him and shot him somewhere else, it's just logically silly. You're saying at this point in time, you interfered with the death of somebody who didn't die till they were over there by moving them over there. How does that work? I'm going to conceal the death I'm about to commit. It doesn't work. There is no evidence that the body was dead prior to falling. I asked the medical examiner. I asked everyone I could. Nobody seems to be able to give me a straight answer. Where he was shot. I went ad nauseum into blood splatter to help document, help them do their job, to determine where he was when he was shot. That was the whole point of 90% of that, to determine where was Cordarius Skelton, where was his body vis-a-vis the person who shot him. That was the whole point of that. We simply don't know. And that's their failure. Because we don't know, you can't convict. If you suspect, you can't convict. If you gravely have a suspicion, you can't convict. One moment. And lastly, if there were a gun in the bedroom and you had seen if there was a gun and you had seen somebody breaking into your car, what do you grab? You don't know if the person is armed. You don't know how many people are out there. What do you grab? You grab your gun. Then you go. You don't go beat the guy, then go back in after having identified yourself to police on a 911 call, told them your name, told them your address, told them what you're doing, and then commit a murder. This is almost a built-in insanity defense. It just doesn't make sense. There was no gun. He grabbed no gun. But even if he did, we don't have a gun connected to this crime. You gotta connect all the dots. You can't just jump over elements of the crime like you jump over Bliss Avenue. Everything must be connected. It is awful. It is sad. It is a tragedy the way Cordelia Skelton died. Flat out shouldn't have happened. Period. End of sentence and stop. No justification. But it's also flat out wrong to convict this man based on this evidence. Nothing further.
Thank you, Mr. Bass. All right, ladies and gentlemen, we need to take a break now. And when we come back, Mr. Rao will be up with the state's closing. So you've heard half the closings, but we need to take a break. I will get you back in here as soon as I can for part 2 of the closings. Because you haven't heard both closings and the law that I need to give you, it's still not time to deliberate. It's time to relax and luxuriate back in the jury room in the hallway back there. We'll get you in here soon. Thank you.
Counsel to the jury.
If you all during the break could talk about whether you think there are any exhibits that shouldn't go back with the jury. There are a few things that have been admitted, like State's Exhibit 1, the certified copy of the conviction, would not go back with the jury. But if you could confirm, because if there's a disagreement, I'll need to work through that once the state's done with its closing and I've given the jury the charge. I'd just like them to be able to start their deliberations as soon as possible after the charge and not delay those things till then. So if you could confer during this break, I'll try to be back in about 15 minutes, but we'll see. Anything, Mr. Bass, before we break?
No, Judge.
Mr. Rao? You'll have your PowerPoint or whatever you're going to use up and ready to go? All right. Thank you, everyone.
3 minutes.
Ms. Rivers, are you ready?
Yes.
Excellent. Let's get on the record in State versus Dennis. Mr. Dennis is in court with his lawyer. Our prosecutors are here. Mr. Rao, are you ready for the jury?
I am.
Mr. Bass?
Yes, sir.
All right, let's bring him in, please. Oh, hey, Deputy Gordon,
Yes.
can you come back out for a second? Mr. Bass, I neglected to give you an opportunity to get on the record an objection you had during Detective Stansel's testimony. He was asked, you actually didn't say objection. You said you wanted to take something up outside the presence of the jury, which we did discuss, but we need to get it on the record now. And you don't have to stay standing if you don't want to, up to you. Mr. Abate asked a very carefully structured question about what was found in 516 Chapel. And the detective, I think, surprised everyone, not the jurors, but the lawyers and Mr. Dennis and myself, by saying, actually, yeah, there was a revolver found in the house. People had enough of a poker face, but you popped up pretty quickly to say, hey, we need to talk about something. And I asked you to hold on to that. You had preserved a concern, didn't want you to articulate it in front of the jury. We talked about it out in the hallway because one of the juror questions was the gun found in the house tested to see if it matched the projectiles? And in the end, my ruling was we're not going to ask this witness about the gun because that witness wasn't actually supposed to talk about guns that were found in the house per your motion in limine, which I had granted. I do not find that the state intentionally elicited that testimony. And I think the detective was just trying to be responsive to the question, but it went outside the parameters that I had set. I do find that the state had let Detective Stansel know in advance, they don't go there with the guns, probably thinking the long gun, the assault rifle, et cetera. And to be clear, none of that was shared with the jury. But that one handgun, I think revolver was. We discussed out in the hallway that it was a different caliber. It was found in Mr. Dennis's father's bedroom. You were okay with the, it didn't match the bullets that were removed from Mr. Skelton. You weren't okay with where was that gun found. And really, since it was your motion in limine, that's sort of what controlled, because I thought it should all come in or none of it. And so in the end, we didn't explore with Detective Stansel anything more than that one semi-non-responsive answer to Mr. Abate's question. That's my recollection of, one, our conversation in the hallway, and two, what's in the record. Of course, the record will speak for itself. What do you want to add to the record about your concern when Detective Stansel answered the way he did?
I agree with Your Honor that the motion in limine was what it was. It was to keep out the guns found in the 516 Chapel Road address. There were 4 guns, all were excluded per Your Honor's granting of that motion. The witness did go into one of the guns that had been excluded per the motion. I objected without use of the word by asking to address it outside the presence. We did hear my objection in the hallway. I believe I preserved it enough for the record. Should we need a record of this in the future? But I don't believe it should have come in. It is here. It is what it is at this point.
Okay, but so we're clear, you did not ask for a curative instruction. You did not ask me to tell the jury to disregard that answer. The form of relief that we discussed was, what are we going to do with the juror question about effectively, tell us more about this gun that was found in the house. And your request was, if it's not going to be limited to simply that gun didn't fire the bullets found in Mr. Skelton, then you didn't want there to be more, i.e. found in the father's room, et cetera. And so per your request, I didn't explore it anymore on behalf of the juror question. You agree with all that?
I do agree.
Okay. Mr. Abadi, it was your witness. Anything you want to add from the state? Okay, thank you. Now the jurors, please.
Oh, I love the redacted on your desk.
Great. Did you share it with Mr. Bass? Okay. Mr. Bass, no issue with the redacted indictment?
Correct.
Judge, for whatever reason, I'm sharing this with the Zoom.
All right, to the jurors.
You can talk about it while they walk in.
It just, for some reason, this doesn't seem to work
The clicker doesn't work.
when I'm putting it on Zoom. It's working now.
Sure. But when it's in Zoom, could it be advanced manually so that Vanna Abate could do it as you say, next slide, please?
Jurors, the president accounted for.
Thank you, Deputy Gordon. Everyone else should be seated. Welcome back. Thanks for your patience. We are going to start the state's closing in just a moment. I think it's an issue with advancing slides. We're going to wing it.
Hopefully,
Okay.
see how it goes. Be a trial of that. Good afternoon, ladies and gentlemen. We're here at the close of the case. You've heard all the evidence that's been presented to you during the course of this particular trial. Now we get to talk to you a little bit about the legal principles that are going to be applicable in this particular case, and then I'll finish it off with the evidence that was presented to you and how it applies as it relates to the law in this particular case. So the defendant is charged with the counts on the indictment. As you see here on this slide, there are 12 counts. He's charged with 1 count of murder, 4 counts of felony murder that are predicated on the felonies as it relates to count 6, count 7, count 9, and count 10. And then in addition to that, he's charged with 2 separate and distinct counts of possession of a firearm by a convicted felon. I'll discuss with you why the indictment is charged in the way that it is as it relates to those counts. And then finally, he's charged with concealing the death of another, as well as tampering with the evidence. And so we'll talk a little bit about the legal principles that apply to this case, the elements of each and every single charge that he's indicted for, as well as the facts of this case that apply to the charges that he's indicted. Before I get into all that, I really want to talk to you about burden of proof and the concept of what beyond a reasonable doubt actually means. So a lot of you may have watched courtroom dramas or TV shows or movies, read novels or books about trials and courtroom procedures and things of that nature. And so you're probably all, at least at some point in time during the course of your life, heard the phrase beyond a reasonable doubt. And so maybe we all have a colloquial understanding of what beyond a reasonable doubt means. But in the context of the legal sphere and the criminal justice system in the trial, there is a legal definition as to what beyond a reasonable doubt is, which is the burden that you'll have to go and determine whether or not we have proved beyond a reasonable doubt. So I first start off by telling you what it's not. So it's not beyond all doubt. It's not a vague or arbitrary doubt that you've developed during the course of this trial. And it's not a doubt beyond a mathematical certainty. So there's not a numerical value that you associate that the state has presented, 51% or 60%, 70% certainty that what happened is what happened. It's literally a doubt that is reasonable. And so the legal definition for reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. It's not seeking doubt. It's looking at the facts and evidence that's been presented to you during the course of this particular trial, sifting through that evidence and making a determination based on logic and reason as it relates to what actually happened in this particular case. And if there is doubt, it has to be based on common sense and reason. Common sense is going to be your biggest asset when you go back there and deliberate as it relates to the facts and evidence that's been presented to you during the course of this trial. Because common sense is what you use to make logical deductions as it relates to what the facts are and what those facts actually mean as it relates to the defendant's guilt in this particular case. So look at the evidence that's been presented to you and see where it takes you as far as the most reasonable, logical conclusion as to what the outcome of this case should be as it relates to your verdict. And so one way I'd like to really conceptualize this for jurors is the difference between what is possible and what is reasonable. So we've all heard the phrase, anything is possible. Anything is possible. Anything could have happened. Anything is possible. That's not the standard that you apply in this particular case as it relates to reasonable doubt. The standard that you apply is what is reasonable. And so what is reasonable in this case? Well, let me give you an example. It's kind of a silly example that I give jurors to conceptualize reasonable doubt, but it's one that I've been told that works. Every now and then, we go to the grocery store to buy groceries. And if any of you pick up cereal, you go to the aisle that has all the cereal in there. You pass by the Fruit Loops, the Honey Nut Cheerios, and let's say Honey Bunches of Oats is your favorite cereal. And that's the one that you get, typically. You go to that specific section in the aisle where there's cereal, and you look at Honey Bunches of Oats. And you see a box that's labeled Honey Bunches of Oats. It's not a translucent box. It's not an open box. It's not a box that you can see inside. It's just a box that says that it's Honey Bunches of Oats, and maybe there's a graphic associated. You don't actually see what's inside the box, right? You just pick up the box and you put it in your cart and you go on your way to the next item on your grocery list. You don't open the box until you get back home and it's time to pour that cereal into the bowl. Right? You don't go into the grocery store and you open the box to make sure that there's Honey Bunches of Oats. You use your common sense and reason based on your life experience that you go into the specific section that has, or specific aisle where there's cereal, you go to the specific section where there's Honey Bunches of Oats and you pick out the box and you know that that's Honey Bunches of Oats because you're using your common sense and reason to deduce that even though you can't see what's inside that box, that all indications point to Honey Bunches of Oats being inside that box. Now, is it possible that the parent company for Honey Bunches of Oats, let's say it's the same parent company that owns Fruit Loops, is it possible that Fruit Loops could in fact be in the box where Honey Bunches of Oats is? And the answer is yes, right? It's possible. Anything is possible. But is it reasonable for you at every turn when you pick up a box of Honey Bunches of Oats at a grocery store, that you open up the box, that you open up any box that you can't exactly see inside to make a determination that it is what it is for it to be? The answer is no, because that's not reasonable to do that. And just like that, ladies and gentlemen, even though you weren't there at the scene, even though you weren't there to witness things yourselves, you use your common sense and reason based on the evidence that's been presented to you during the course of this trial from that witness stand to make a determination. You don't actually have to be there. You look at the indicators that have been presented to you and make the most logical, common sense deduction as it relates to what the evidence shows in this case. And in doing that, when you go back and to deliberate, the judge is going to give you a list of things as it relates to the law and the legal principles that you have to go back there and deliberate on. And some of those are going to include the things that you can and cannot consider as it relates to how you form your verdict. And so as it relates to things that you can't consider, there are things such as passion and sentiment, public opinion, like or dislike of the parties, in this particular case, like or dislike of the police, disagreements with any of the law that the judge charges you with, any thought as it relates to consequences, penalty, or punishment as it relates to what your verdict will be, and certainly not any prejudice, sympathy that you might have for any party. It is being as objective as you possibly can, while also taking in your life experiences and common sense to render a verdict in this particular case. And the most important thing on this list, which I think is particularly relevant given the defense's presentation of their case,
is speculation and conjecture. Because the entirety of their defense has been based on speculation and conjecture, not based on objective facts that have been presented to you, but on conjecture as to what could be, what might be, no matter how unreasonable that position is. And so I want you to take that into consideration when we talk a little bit about the facts of this particular case and what the most reasonable conclusion is from the objective facts in this case. As it relates to the things that you can and should and have a duty to consider, first and foremost, of course, will be the elements of the crime, which the judge will charge you with and which I will discuss with you shortly. The law and the legal principles, forensics and expert testimony as it relates to the testimony of the medical examiner and the firearms examiner, photos and documents of the scene, the overall area, as well as the CAD report, so we know what time 911 was called, things of that nature. And then also to consider what is the defense, which he's pretty much told you, it wasn't Brenton Pence that shot and killed Cordarius Skelton on the morning hours of February 5th, 2024, which we will shortly talk about how all the evidence actually does in fact point to the defendant, Brenton Dennis, as being the killer of Cordarius Skelton. And we know that through his actions, through the witness testimony, as well as the evidence that has been presented to you during the course of this trial. And most importantly, ladies and gentlemen, and I don't mean to be repetitive, but common sense is your biggest asset when you go back there and deliberate as it relates to the logical conclusion in this particular case. And the reason I say that is because based on the evidence, there's two types of evidence that has been presented to you. They fall into two categories. There's direct evidence and there's circumstantial evidence. So direct evidence is what points immediately to an issue. For instance, when Saul Hyman or James Campbell or Chelsea Davis, all of whom were lay witnesses in the general area at the time that this event happened, all the things that they told you in terms of what they saw, what they heard, that's all direct evidence that points immediately to an issue that you can take for your consideration. Circumstantial evidence is taking all those direct evidence facts, looping them together, and making a logical inference from those facts as it relates to a related fact. So, what do I mean by that? Circumstantial evidence. It's not working. Circumstantial evidence. So, to give you an example of circumstantial evidence, one that I like to give jurors, is that if any of us drive a car that requires gas, at some point in time during the course of our time driving a vehicle, we all have to stop at a gas station. We all have to stop at the pump. And when if you're anything like me, you wait until the light gets yellow until you have to refill it. And so you go to the pump, get out of your car, you go to put your credit card in there, you select the grade of fuel that you need, you remove the nozzle, you open the tank, put the nozzle into the tank. You press down on the lever, and all of a sudden you see the amount of money that you are paying go up, you see the amount of gallons going up, and you hear the sound that's consistent with your life experience as gas going into the car. You eventually stop fueling up your car, put the nozzle back into the tank, put the nozzle back into the station, and then get into your car. You turn the ignition on, and you press the accelerator, and you're able to go. And after 50 to 100 miles later, you're realizing that you're able to drive continuously, even though previously you did not have gas in the car until after you filled up. And that's how you know that there was gas in your car. Even though you did not actually see the gas go into the car, all the indicators presented to you during the course of your time at the gas station, even just leading up to the gas station, gives you the indication that even though you did not see something, it in fact happened. Based on logical, reasonable deductions that you can make, based on the evidence presented to you. And for the record, there's no distinction in terms of the weight that you get to place on direct evidence versus circumstantial evidence. Just because someone says that they see something doesn't mean that that gives it any greater value or less value than something that you have to logically deduce from a group of related facts. Evidence, either circumstantial or direct, The weight that it's given is dependent upon the weight that you decide to place on it. But there is no greater or lesser value between the two evidence. And the reason why that is, the reason why circumstantial evidence is given the importance that it is in the legal system is because a lot of times, as it may be surprising to you, and may not really, crime doesn't always happen in the light. Meaning there's not always going to be witnesses that see someone get murdered, someone get raped, someone get armed robbery. There's not always going to be witnesses. And so how does the law, how does the legal system, how do we as a community make a determination as to how to hold someone accountable when they are lucky enough not to have witnesses see the actual act in question? We look at the evidence surrounding that particular act, the facts and evidence that's been presented to you surrounding that particular time period. And you draw them together. And in drawing that together, you make a logical, reasonable deduction and inference that then becomes a fact in and of itself for your consideration as it relates to supporting the verdict that you have. And that's how you bring that from the darkness to the light. So examples of direct and circumstantial evidence in this particular case. So an example of direct evidence would be Chelsea Davis testifying and telling each and every one of you jurors that she saw the defendant take a small gun out of the drawer that you observed on State's Exhibits 114, where that monitor was on top of, and then leave the bedroom almost immediately thereafter. That's direct evidence. That's something that she saw, that she is telling you that she saw. Saul Hyman, observing a person laying on the ground in the front yard of 516 Chappelle Road, is direct evidence. He is telling you what he saw and observed on the morning hours of February 5th, 2024, and that he observed 3 people walking in tandem, close together, in the direction of the open field where Cordarius Skelton's body was ultimately recovered soon after. The defendant himself admitted to Detective Stansel that he engaged in a fight with the victim after he suspected the victim of trying to get entry into his vehicle. That's direct evidence. That's something the defendant himself admitted to, told Detective Stansel. In addition to that, the defendant himself admitted that he took Cordarius Skelton to the field that Detective Stansel was talking about when he was asking him, how did he end up in that field? He was at your residence, you say. How did he end up in that field? The defendant himself admitted that he took him to the field. That's direct evidence. The video surveillance, which we'll discuss towards the end of this presentation, where Detective Stansel, and you all, if you didn't have the opportunity, will certainly have the opportunity when you go back there to play the video as many times as you would like, can see people walking in the direction of the open field and then walking back in the direction of 516 Chappelle Road minutes later. And the medical examiners and the GBI firearms examiner saying that the projectiles recovered from the victim's body, from the victim's head, were .38 caliber bullets, known to be fired largely from revolvers, consistent with what Chelsea Davis said that she observed the defendant take out of his drawer on the morning of February 5th, 2024. Those are all examples of direct evidence. Now, as I indicated and asked Chelsea, and the state hasn't hid from this, there is not a witness that says that they observed the defendant pull the trigger and kill Cordarius Skelton. No one has hid from that. But the reality is that if that were what it took to hold people accountable, there would be a lot more people who aren't held accountable for the crimes that they commit. Because someone wasn't there at the time that they committed the crime to actually observe them pull the trigger. That is why circumstantial evidence is given the importance that it is. Because circumstantially, we can prove that the defendant pulled the trigger, shot and killed Cordarius Skelton. How? Well, in taking all the facts, as I gave right now as examples of direct evidence in this case, taking them all together, what is the logical, reasonable conclusion from that? It is that the defendant beat up the victim, as he himself admitted to. Took the revolver from his bedroom, went up to the victim, took the victim to the open field, as observed by Saul Jaime, when he observed two people with the person who fell on the ground walk in the direction of the open field and hearing the shots while he was in his kitchen. That's all circumstantial evidence that shows that the logical, reasonable deduction that you can make from the group of related facts is that the defendant is the one responsible for murdering Cordarius Skelton. And so those are the two types of evidence that you will have before you. Those are the two categories of evidence. The types of evidence that you've been presented with come in the form of exhibits, such as the photographs, the video, the 911 audio recordings, and the documents that have been presented to the witnesses in this particular case. The law enforcement witnesses, the ones that responded to the scene, processed the scene, and led the investigation, that's all evidence in this particular case as it relates to the testimony at this trial, as well as the expert testimony from the firearms examiner, as well as the medical examiner as it relates to the cause and manner of death, as well as what the caliber of the projectiles were that were recovered from the victim during the autopsy. That's all evidence. Most importantly, the lay witnesses, the people who were actually there in and around the time these events transpired, who gave some light as to what actually happened, even though they did not actually see Brent and Dennis shoot and kill Cordarius Skelton. They're able to give you context and a group of facts that you can then use to deduce the logical conclusion as it relates to who is responsible for why Cordarius Skelton has 2 gunshot wounds to his head. And ladies and gentlemen, the testimony of a single witness, if believed, is sufficient to establish a fact that you use to support your evidence. That means that if you believe Chelsea Davis, without the assistance of the testimony of Saul Jaime and James Campbell corroborating her, that's sufficient to establish a fact. You don't need anyone else. Just like if you had Saul Jaime just by himself, you don't need other witnesses to corroborate this testimony. You don't need other witnesses to corroborate James Campbell's testimony about the gunshots that occurred. If they're credible in your eyes, that is sufficient to establish a fact. There is no legal requirement for corroboration, even though the reality is that even though they don't know each other, that Saul Jaime doesn't know the defendant, they don't know Chelsea, he doesn't know Chelsea, he doesn't know James Campbell, that James Campbell doesn't know Chelsea, James Campbell doesn't know Saul, that Chelsea doesn't know the other two, and in many ways they corroborate each other, which we'll discuss when we talk about their testimony and the facts in this case. They actually corroborate each other, even though that there's no legal requirement that there's corroboration, that supports and bolsters each of their testimonies that they presented to you during the course of this trial. And in so doing, looking at their testimony, the manner in which they testified, the things that they testified to, the reason why they testified to the things that they did based on their ability to see and observe,
Those are all things that you get to take into consideration as to the value that you place on a particular witness. Now, I want to talk a little bit about credibility, specifically as it relates to Chelsea. Now, we were upfront and told you that Chelsea did not say the things that she testified to on the stand to law enforcement hours after the event transpired when they were interviewed. And she indicated to you that she was scared, that she was nervous. She had never been in a situation like this before. And she told you her anxiety kicked in. And I'm not excusing that. I absolutely believe that she should have told law enforcement at the time the things that she testified to, but there are reasons as to why she did what she did. But here's the thing. Why did she testify to the things that she did here during the course of this trial when she had the opportunity to tell her truth? Is it because she hates the defendant? Because of some bias that she has against the defendant? Because of this supposed ex-girlfriend, or excuse me, new girlfriend, of which there's no evidence of, which she said that there was no girlfriend at the time that they were together, that there's no evidence of that? Or is it because she's finally telling you the things that she saw and observed and heard? And if she, in fact, had the bias against the defendant such that she would lie to you, ladies and gentlemen, why would she just not say that she observed the defendant shoot on that monitor? And that the reason why she didn't tell law enforcement or come forth with it is because the defendant was threatening her, that the defendant's family was threatening her, and she was scared that if she told the truth, that somehow, some way, given that she still lives in the city, that they would come after her. Why not just say that? Because that's not what happened, because she didn't actually see it. All she can tell you are the things that she heard and observed. She is just one piece of the puzzle, completing the picture. Not trying to embellish or minimize her involvement in this case, just to tell you, finally get that weight off as it relates to what she saw, what she heard, and what she observed. As it relates to the elements of the crime, as it relates to each and every charge, you have to prove that the defendant intended to commit the act. That's not the intent to commit a crime, it's simply to commit the act and conduct that supports the charge or charges that he has been accused of on the indictment. It's not the intent to violate the law, it's simply just the intent to commit the act. Simply just the intent to brandish a weapon and pull the trigger in the direction for Darius Skelton, resulting in 2 projectiles lodged in his head. So count 1, murder. Unlawfully and with malice causes the death of another human being. Now, jurors get sometimes hung up on the concept of malice. It's not how we colloquially refer to it. It's not hatred, it's not ill will. It's simply just the intention to commit an unjustifiable kill. That's all it is. That's what malice means in the context of the legal sphere as it relates to the charge of murder. It's not ill will, hatred. It's not waking up one particular morning and making a decision that they want to kill someone in particular or just someone in general. It's just the unlawful intention to kill in the moment that you commit the act. And so there are legal definitions as it relates to malice. There's express malice and implied malice. Express malice is legally defined as the deliberate intention to unlawfully take away the life of another human being shown by external circumstances capable of proof. And implied malice is legally defined as when no considerable provocation appears and when all the circumstances of the killing shown abandoned and malignant part. This is a lot of legal jargon. I'm not sure why they haven't simplified for even us lawyers to really understand what they mean, but how I've been able to conceptualize express malice and implied malice in my time prosecuting homicides is this. Express malice is simply just showing that actions are deliberate. And implied malice is actions that show disregard for human life that you can draw from the implications of the evidence presented to you during the course of a particular trial. So for instance, a deliberate action is intentionally pulling out a firearm and shooting somebody. without any justification whatsoever for pulling that trigger. Not just once, but at least twice. Implied malice is disregard for human life. That you already beat this man into a ground, that you pin yourself on top, go back inside the room, take a revolver, take him to the open field, and shoot him again. That's all actions that show a disregard for human life by leaving him out to die in an abandoned field that no one could see until daylight broke. In either case, however you find malice, either expressed, implied, or both, all malice means is that the killing was unjustified in this particular case, yet under the applicable law. The defendant's actions here in this particular case show both express and implied malice in this particular case, because anytime you point your firearm in the direction of an unarmed individual and shoot them multiple times, those are deliberate actions. It's a conscious, deliberate, intentional act to take somebody's life in this particular case. And it shows a total disregard for human life when you take that man to an abandoned field and leave him to die. And as I indicated, malice does not mean premeditation, and therefore it is not a requirement for your consideration to support the charge of murder. And the malice that's required to form murder, just a simple act of killing someone unjustly, can be formed at any moment. There's no premeditation, there's no length of time that is required. The malice that you form as it relates to pulling the trigger can be formed at an instant. Now, as it relates to counts 2 through 5, felony murder, this is unlike malice murder. You do not require proof of malice. So there's no need for you to find express or implied malice. All that's required is that you prove that a death occurred, that there's a causal relation to the death that occurred to the predicate felony act that you have been indicted for to support a felony murder charge. Essentially, it's committing an inherently dangerous felony, and as a result of committing that felony, it results in the death of another. And that there's a causal connection between that predicate felony and the death. So in this particular case, in counts 2 through 5, felony murder is supported by the following predicate felonies: aggravated assault, false imprisonment, and 2 separate and distinct counts of possession of a firearm by a convicted felon. And that a death occurred as it relates to the commission of these particular acts. So, count 6, aggravated assault. What are these predicate felonies and what are the elements of these felonies? Well, count 6, aggravated assault, requires an assault with a deadly weapon. And the fact that there's evidence to show that the defendant was in possession of a firearm in and of itself is proof that it was with a deadly weapon, because as a matter of law, a firearm is considered a deadly weapon. To constitute an assault, you do not need to show actual injury to the victim, although of course in this particular case, we've seen the autopsy photo, so we know that there were injuries to Cordarius' skeleton as it relates to the shooting. In this particular case, the aggravated assault was predicated on the act of brandishing a firearm in the direction of Cordarius' skeleton and shooting. Count 7, false imprisonment. The requirements are intentionally detaining someone without legal authority in violation of their liberty. You don't actually get to just detain somebody unless you're a law enforcement officer. So I agree with Mr. Bass that he did do the right thing and call 911, but he took it a few steps further.
Objection, misstates the law.
So, ladies and gentlemen, the lawyers are free to share with you their understanding of what the law is. Ultimately, I'll be instructing you on what that law is. It'll be in the jury charge that you'll have with you during your deliberation. So if you're hearing something now that's inconsistent with the written document you get, the written document controls.
In addition to pinning him down on the ground after beating to the point that he could not move, per Chelsea Davis's testimony, when she said that he looked beat, he was on the ground. They took him to the field. Now, Saul Jaime says that the three of them, from the vantage point that he had, looked like they were walking close together in tandem, essentially, side by side, shoulder by shoulder. It's consistent with being taken by force, holding the victim, and dragging him to the location where his body was ultimately recovered. Remember, Chelsea Davis said he was on the ground. He wasn't really moving. He looked beat, which is consistent with what the defendant said when he said he beat him. So he didn't just magically get up on his own volition and start walking, which would also be inconsistent with what Saul Jaime saw, which was that the three of them, to include the person that was on the ground, started moving in the direction of the open field where Cordarius Skelton's body was ultimately recovered. That's also a detention. It's not free to leave. They're not doing him a favor. They're taking him there for a purpose. It's not a purpose that I'm sure Cordarius Skelton wanted. As we saw the final results on the morning of February 5th, 2024. Now, count 8, possession of a firearm during the commission of a felony. It's essentially having on your person a firearm during the commission of a felony. And there are 4 felonies that are listed in that particular charge. It's murder, felony murder, aggravated assault, and false imprisonment. And all that you have to do in order to find the defendant guilty on count 8 is to find at least one of the following felonies: murder, or felony murder, or aggravated assault, or false imprisonment, or all of the above. But all that you need to support the conviction on count 8 is to find the defendant guilty of one of the following 4 predicate felonies. Count 9, possession of a firearm by a convicted felon, essentially is that the defendant was in possession of a firearm on the morning of February 5th, 2024. That's all that we have to prove, that he had a firearm in his possession. Chelsea Davis told you that he had a firearm in his possession. And while he had a firearm in his possession, he was a convicted felon, having been convicted of a felony on September 13th, 2022, with the case number that's listed on this slide. And that he was unlawfully possessing that firearm in the morning hours of February 5th, 2024. That is what is needed to support the conviction on count 9. Count 10, possession of a firearm by a convicted felon. It's a little bit different than count 9. Requires a person possessing a firearm during the commission of a felony involving the person of another, having been previously convicted of a qualifying felony. Now, the defense and the state have stipulated that the requirement that the defendant having been a convicted felon for count 9 and the defendant having been convicted of a qualifying felony has been agreed upon. So the fact that he is a convicted felon for the purposes of count 9 and count 10 have been stipulated. You have to find whether or not you believe the defendant was in possession of a firearm. So you have to just completely disregard Chelsea Davis's testimony in order to do that. So if you believe Chelsea Davis, the defendant is guilty on count 9 and count 10. Now, count 11, concealing the death of another. The requirements in order to prove this charge. That the defendant concealed the death of another person in a manner that hindered the discovery of whether that person was unlawfully killed. The defendant did a good job of this because, as you heard Officer Quinn testify, that in response to the shots fired call placed by James Campbell at 6:38 a.m., he responded to the scene at 6:46 after having been dispatched at 6:41 a.m. And for approximately 20 minutes up until 7:09 a.m., he cleared the call. He could not find the body. He could not find any witnesses. He could not see anything in the field that was presented to him. You all have the pictures of that crime scene as it relates, you could not see the body until the crime scene tech got closer and closer and closer. And only until then were they able to get clear enough photographs for you to observe. Not from the street, but close and close and close. He did a pretty good job of concealing the death for Darius Skelton. Tampering with evidence, the last count in the indictment. The requirements, knowingly destroyed or concealed physical evidence. Now you heard crime scene tech Sharon Davis, when she was testifying about processing the crime scene, she had put evidence placard 3 near the body. And the reason why she did that is because the body in and of itself is a piece of evidence that homicide investigators and medical examiners and crime scene techs can use to then establish an investigation and make determinations as it relates to any evidentiary value that they have. And it actually was a piece of evidence because that's how it tied to 516 Chappelle Road, because they saw that puffer jacket, they saw the description of the victim, and matched it to what was the description was listed on the CAD report when the defendant's younger brother called 911 and gave a description. So that's actually a piece of evidence that led them to 516 Chappelle Road, and the defendant tampered by taking it to the open field at 564 Chappelle Road and leaving it there, not telling anybody. Motive is not something that you all, that we are legally required to prove. And oftentimes, there aren't reasons for why someone does it. In this particular case, we have evidence that Chelsea Davis testified to that the defendant immediately sprung into action as soon as he saw that his car was attempted to be broken into. And obviously was upset enough to the point where he was able to beat the victim into the ground. There was a fight between the two of them, and he got the better of them, and he left him on the ground. And then he comes back to the bedroom and takes a gun to go back out. He doesn't initially, unlike what the defense was trying to tell you, immediately take a gun and go out to the scene. He beats them to the ground, then comes back and takes the gun. Why does he need to do that? What would be the reason for taking a gun and going back in the direction you came from, where the victim is sprawled out on the ground, if you beat him? As testified to by Chelsea Davis, as told by the defendant himself to Detective Stansel, that he beat them. So what would be the reason that you would need to go back and get a firearm if you're not intending to use it? Because at that point, the evidence is that he's on the ground. He's beat. That's the defendant's own words, and it's corroborated by Chelsea Davis. Why did the defendant do this? Oftentimes, as you've read in the newspapers and as you may have observed in life experiences, people do things out of anger. Sometimes you just see red. And I can understand not wanting to have a vehicle that you paid off, that you respect, that you clean up, that you work hard for, getting broken into, or at least the attempt. I can absolutely understand. I'm sure each and every one of you can understand that too. You all work hard for the things that you have. You don't want anyone else to mess with it. I can understand that sentiment from the defendant. I absolutely can. I am not attempting to disregard that in any way, shape, or form. I'm not hiding from the fact that Darius Skelton probably was attempting to get into the vehicle. But where you take things a step too far is by going back there and getting the gun. And then shortly after, everyone hears gunshots. Is it just magically someone else? Or does all the evidence point to one person who's the reason why Darius Skelton is no longer with us? The only way to describe these acts that Mr. Abadi indicated is that the defendant acted as judge, jury, and execution. Because there is no excuse and there is no justification for why Darius Skelton has 2 bullet holes in his head. There's no reason why he's a Fulton County medical examiner number in this particular case. He has made every attempt to conceal, distract,
in disguise his conduct as it relates to the events that occurred after that 911 call, leading up to shooting, killing Cordarius Skelton, and disposing of his body. And if you follow the facts, you follow the evidence that's been presented to you, the only logical conclusion that you have before you is that all the evidence points to Cordarius Skelton, or excuse me, I'm sorry, Brenton Dennis, for the murder of Cordarius Skelton. So the question that's been presented to us, there's oftentimes a question of why did something happen? Was it justified? That's not the instance in this case. There's going to be no law on justification or anything like that, because the killing is not justified. So the question that we have before us, ladies and gentlemen, is who is responsible for Cordarius Skelton's murder? And beyond a reasonable doubt, it's the defendant. So how do we know this? Okay? Well, we start with Chelsea Davis's statement and testimony that when she woke up on the morning of February 5th, 2024, she looks to the defendant, who's leaning in towards the monitor, and he exclaims, "Someone is breaking into my car," and immediately makes a beeline out of the room. She then goes up to that same monitor, the same monitor that the defendant looked at, and sees the defendant and the victim, unbeknownst to her at the time that he was eventually going to be the victim in this case, engaging in a fight. And she goes out to the front porch, goes down the steps as she testified to, and in the front yard, by the sidewalk and on the grass, the two of them are fighting. Again, something that the defendant himself has admitted to. But they were fighting and he beat him. She then gets escorted by the defendant's younger brother, who's out. That kind of corroborates Saul Hynek. Because eventually when he goes back out in the front, he sees two people standing above the person on the ground. So we know it's not just the defendant out. The defendant's younger brother is also out there as well. And when she gets escorted by the defendant's younger brother, she hears the defendant say, "Hey, call 911. After the fight, after what she observes, in terms of what she sees when she goes out. And when she gets back to her room, she can hear the 911 call being placed. And we know that the 911 call was placed at 6:05 a.m. So that is when the fight is ensuing, and we hear Brenton Dennis, and look, the fight's over. You know how we know that? Because we don't hear the victim. It's just Brenton Dennis and his younger brother talking to the 911 operator. We don't hear anybody else. He has won the fight, and he is on the ground. Then Chelsea says that she looks toward the monitor when she's back in the bedroom and sees the defendant pinning the victim to the ground. And later on, she observes the defendant get up and walk back into the direction of the front door. And soon after that, he's in the bedroom. And he walks towards where the monitor is, pulls out that drawer that we saw in States 114, and procures a revolver, a small revolver, and walks back out. They don't share any words or anything like that. He just goes back out. And he, soon after, is on the front yard. Well, how do we know that? Well, Saul Hynek, who lives across the street, as he testifies, the same house that the defense attorney went to and spoke to him in front of the same yard that Saul Hynek said he observed the man on the ground with two people over him. That's after he hears something that he believes to be a gunshot that startles him enough to where he walks from the back of the house all the way to the front window to observe what's transpiring on the front yard of 516 Chapella Road. He then sees
the man on the ground, as well as the two individuals beside him, get up, walk in close proximity, consistent with holding the victim in the direction of the open field and gas station, where the victim's body was ultimately recovered. Saul Jaime then goes back to his kitchen after he sees what he sees. And on the surveillance video, as Detective Stansel testified, is you will have an opportunity to go back and observe if you haven't already from what was presented to you, because it is in evidence. The surveillance shows two people appearing to carry something at approximately 6:32 a.m. in the direction, walking in the direction, or towards the direction of the open field where Darius' skeleton, his body was ultimately recovered. And then at approximately 6:35, it shows two people walk back in the direction of where 516 Chappelle Road would be. After witnessing the three people walk in the direction of that open field, he's in his kitchen, Mr. Jaime, and he hears two gunshots. That's consistent with what Chelsea Davis says, because remember, her testimony was that approximately 7 to 10 minutes after she saw the defendant take the firearm from the drawer and walk back out in the direction he came from, she hears what she believes to be two gunshots. James Campbell hears gunshots as well. And as he testified to, it came from the general direction of where the Exxon and open field would have worked. And as he testified to, approximately 2 minutes in his words, after hearing the last gunshot, he calls 911. And we know the exact time in which he called 911 because we have the CAD report. So we know that he placed his call at 6:38, it says PM, but I meant to say AM. 6:38 AM. So we see two people appearing to carry something, walking in the direction of the open field at 6:32 AM. We see two people walk back in the direction of Chappelle Road at 6:35. The shooting has already happened. And approximately 3 minutes later, James Campbell calls 911. He said, 2 minutes after I called 911. That is consistent and corroborates what we see and hear as it relates to what the witnesses have told us in terms of what they observed. Corroboration. Chelsea Davis, Saul Jaime, James Campbell corroborate each other. They essentially form a triangle. And even though they don't know each other, they've never really spoken to each other, they all kind of corroborate each other in many ways. They all see different things at different times, have different observations, but when you take them all together and you bundle them up and you sift through them, what is the logical conclusion from the evidence? It's that the defendant took the firearm, the revolver, from the drawer, walked back out. Saul Jaime says he heard a shot. Then Saul Jaime says that he sees the two people who we know to at least one of them be Cordarius Skelton, based using our common sense and deduction, and the other person being the defendant. I'm not going to cast aspersions on the defendant's younger brother or father, but we know at least one other person was with him, walking the victim in the direction of 564 Chappelle Road, the vacant lot. And that James Campbell hears a gunshot emanating from the open field. Consistent with the time frame that we see on the surveillance video of the defendant walking towards the field that he admitted that he took him to. I think we're missing that fact. The defendant himself said he took him to the field. And then walked back. Obviously, you would have had to walk back because eventually he got into his car and he left. His car wasn't there on scene. So what we see on the video, in conjunction with the testimony of the lay witnesses, in conjunction with the firearms examiner, in conjunction with the medical examiner, all point to one person being responsible for Cordarius Skelton's murder. So as I stated, you'll have the video there if you choose to review it again. And here are some of the timestamps that I want you to take, okay? At 6:32 a.m., which is at approximately 2 minutes and 13 seconds into the video, to 6:33 a.m., which is approximately 3 minutes and 22 seconds into the video. And in addition to that, at 6:34 a.m., 4 minutes and 16 seconds up to 4 minutes and 44 seconds into the video, you see two people appearing to carry something in between them, walking from the direction of 516 Chappelle Road towards the direction of where you see Cordarius Skelton's body ultimately recovered in this case. At 6:35 a.m., which is 5 minutes and 17 seconds into the video, you observe something that would be consistent with a muzzle flash. And at 5 minutes and 39 seconds, also at 6:35 a.m., you see those two individuals walking back in the direction of 516 Chappelle Road. That is the defendant and whoever he took with him, leaving the scene of the crime after the defendant used that revolver to shoot and kill Cordarius Skelton. And it's 6:36 a.m., approximately 5 minutes and 44 seconds into the video. They're back on Chappelle Road. So, the defense's case. I told you earlier, it's been largely based on speculation and conjecture and far-fetched ideas as to what could have happened. One of them was there are drug dealers in the area. And that's it. Well, if any one of you is familiar with the city of Atlanta or Fulton County, there are drug dealers everywhere. I'm not saying that as a joke. That's actually true. So the fact that there are drug dealers in that area, in and of itself, is I'm not sure how connected to this particular case. Simple fact that there are drug dealers in the area. I don't know how that's connected to this case. Then there's no evidence of a fight. So we keep hearing about blood spatter and things like that at 516 Chappelle Road and the lack thereof, and that there's no connection to a gun. Well, one, the defendant in himself admitted that there was a fight. So that kind of solves that issue. There was in fact a fight because he himself told you that. But it's also, even if he hadn't, there's Chelsea Davis telling you that there was a fight between the victim and the defendant. So there was a fight. I'm not sure why we're concentrating on the lack thereof when the defendant said that there was a fight. That's the evidence. And that there's no connection to a gun. Well, if you believe Chelsea Davis, who sat in that chair, took an oath, looked each and every one of you, and told you that she observed the defendant come into the bedroom and take what she believed and what she saw was a small revolver.
Objection misstates the evidence.
Ladies and gentlemen, you all are the finders of fact. I told you a few times now, the lawyers are going to share with you what they recall the evidence to be. You can be persuaded by that, but you don't have to be. You're just giving these lawyers a good listen.
I appreciate that. But with respect to Chelsea Davis's testimony, if you recall, she said that she observed a small gun being procured by the defendant from that drawer. And she said that it is consistent with the photograph that she had an opportunity to look at in front of all of you and say, yes, it's that one, which is a revolver. That was confirmed by the firearms examiner today, that is in fact a revolver. So the gun that she observed looked like a revolver. You have to ignore what Saul Jaime said, that he lived across the street, that he observed the things that he observed. You'd have to ignore Chelsea Davis's testimony. You'd have to ignore James Campbell's testimony in order to acquit the defendant. You just have to ignore it, not provided any value whatsoever in order to acquit the defendant. Because when you take all of those things together, they point to only one logical conclusion. It's that the defendant is guilty of the acts that he's been charged with. The defendant himself admits to beating the victim. The defendant himself admits to taking the victim to the scene where his body was ultimately recovered. When questioned, how did he get from 516 Chappelle Road to the open lot where his body was recovered? He admits that he took him. He just couldn't take it a step further and say that he did. That's okay, because we have the evidence to prove that he did. And so ultimately, ladies and gentlemen, what you do today and with your verdict matters, because this is about holding someone accountable for the conduct that they committed on the morning hours of February 5th, 2024. And the defense attorney is correct. We didn't charge him with the aggravated assault or the assault or battery of Cordarius Skelton. We theoretically could have, but the reality is we can understand why he's doing what he's doing in that moment to protect his values. What we cannot get on board with are the steps that he takes after the fact. When he shoots Cordarius Skelton, when he takes his body to the field at 564 Chappelle Road and shoots him and leaves him for dead. No one deserves that, no matter who you are. No one deserves to be unjustly taken away from this right, regardless of who you are. Unless there is a justification, of which there is not in this case. Your life does not deserve to be, no matter who you are. He had the right to prevent the victim from breaking into his car, but he did not have the right to take his life. The defendant acted as judge, jury, and executioner. And beyond a reasonable doubt, the only logical, reasonable conclusion as it relates to who shot and killed Cordarius Skelton is sitting at that table, the defendant. All the evidence points towards him, despite the defense's attempts to distract him from the objective evidence in this particular case. The defendant is guilty beyond a reasonable doubt when you take into account the testimony, Chelsea Davis, Saul Jaime, James Campbell, the medical examiner, the firearms examiner, and all the other witnesses. You take them, you put them together, and you draw the logical conclusion in this case. The defendant is guilty beyond a reasonable doubt on all of the charges that he's been indicted. Ladies and gentlemen, I appreciate your time. Thank you.
Thank you, Mr. Rao. So ladies and gentlemen, we are at the point where I'm going to charge you with the law. I'm going to give you a little break first because it is much less interesting and interactive and dynamic than what the lawyers just shared with you. So in a moment, walk down the hallway as a group, not as a group, but just shake it all about. And then we're going to come back in. I'll charge you. That should only take about 15, 20 minutes, which means it won't even be 4:30-ish when I finish that. And then you're going to be in charge of schedule. You're going to start your deliberations today. You may only go 30 minutes because you want to stop at 5. We can keep you, you can stay here, up until 6:40-ish. The last shuttle, I think, runs at 7. We wouldn't let you be here beyond the last shuttle. We'll get you back to your cars, red, yellow lot. But we also have all day tomorrow. And so you may say, you know what, you've given us the law, it's been a long day, we want to start our deliberations tomorrow morning. When the case is put in your lap, you run the clock. So that'll be a little shift from how things have been. But I do want you to be a little more refreshed for the law that I need to give you. So we're going to take a quick break and get you back in here for you to receive the law, and we will go from there. Please don't talk about the case. It's not time yet. And don't throw whatever you just threw. Mr. Rao, anything we need to discuss before we take a quick break?
No, Your Honor.
Mr. Bass?
No, sir.
Okay, it really is going to be like 2-3 minutes. I don't know that I'll even leave. I just want them to be a little perked up for the charge. Exactly, that's what I want them to do. And then I'll charge them. You all have a copy of what I'll be reading to them. I didn't mention this to you, Mr. Bass. The state's seen it before. I'm going to have up on all the screens a PowerPoint that is charge by charge. So those who do better seeing will also be able to see, but it's verbatim what is in the jury charge they're going to get. So I'll read from this, but that's what'll be up on the screen. No bouncing ball. All right.
When the jury lasts for like 5-10 minutes.
Or they want a slightly longer break. Okay. Let's be back here in 6 minutes, and if we can reel them in, great. If we have to wait a few more, we'll wait a few more. Thank you. We've got the defendant and his lawyer and the prosecutors here. Before I bring the jury in to charge them, Mr. Abate handed me a thumb drive that has the digital exhibits minus Mr. Dennis's statement to Detective Stansel. So what is on the thumb drive?
4 and 6, which are the 911 calls, and then statement 2, which is the video surveillance.
We'll call it the Exxon tape?
Yes.
Okay, so 3 files.
Yes, well, 3 files, the video surveillance has 2 files in it.
Okay. And sometimes there's a player or whatnot, but in terms of evidence, it's those 3 exhibits, 911, and Exxon footage. Okay, great. Thank you. Mr. Bass, any issue with that going back to the jury?
No, Judge.
Great, we'll do that. Let's bring the jurors in, please.
All right, so jury. Jury, the president of the county court.
Thank you, Deputy Gordon. You all can be seated, please. All right, ladies and gentlemen, it is time for the jury charge, the law that I'm going to give you that you must apply to the facts as you find them to be. You remember, hopefully, at the start of the trial, I told you, you guys are the fact finders. You're going to decide based on the evidence, lack of evidence, conflicts in the evidence, what happened in this situation. And then you lay those facts out next to the elements of each of the 12 offenses to say, did the state meet its burden? Did it prove, if the element was that the person had to be left-handed, was it proven beyond a reasonable doubt that someone was left-handed? That's not an element in this case, but that's what you'll be doing as part of your deliberations. So I'm going to give you this law. You must take it as it is. You don't get to amend it and say, I think it doesn't matter whether the guy was left-handed or right-handed. If that's an element of the crime, that's what our legislature has said an element of crime X is, and we are all bound by that. I will be reading to you from the document you'll have with you. While I'm reading it on the screen, paragraph by paragraph will be what I'm reading. Some folks like to see it while they hear it, keeps you awake longer, easier to process, however you want to do it. Assuming both those screens are on, you'll be able to follow along. You're welcome to take notes. I apologize in advance that some of what I'm going to share with you is going to seem stilted or legalistic. It's the law, after all. But there's certain concepts in criminal law that I'm obligated to describe in certain ways, as in use these specific words. For example, at one point, you're going to hear me say the phrase abandoned and malignant heart. And to me, that always is an image of someone's heart on the ground with a tumor in it that they left alone. It was abandoned and it's malignant. Of course, it doesn't mean anything like that at all, but that's the phrasing that I have to use in describing something to you. And I'm not doing that to drop big words on you, but it's what's required. But where I am able, I try to make the law accessible so that I understand it and so that you understand it. With that, let's get into this. Grand jury has indicted the defendant for murder, felony murder, aggravated assault, false imprisonment, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, use of a firearm by a convicted felon during the commission of a felony, concealing the death of another, and tampering with evidence. You will have that indictment, as I promised you, during your deliberations, so you can read it and see exactly what is charged and how. The defendant has entered a plea of not guilty to these charges. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of 1 or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. And you'll be getting those elements a little bit later in this discussion. There's no burden of proof upon the defendant, and the burden never shifts to him. If the defendant presents a defense, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given, and that reason arises from your careful consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all that evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged or merely raises speculation about the defendant's guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law, and that's what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law that I'm giving you to the facts that you find. You must decide this case based only on the evidence presented here during trial. And that evidence consists of testimony, exhibits, and that one stipulation that I read to you. And again, that stipulation is on paper. You'll have it back in the jury room. Evidence does not include the indictment, the plea of not guilty, anything said by me or the lawyers, to include those lawyers' opening and closing remarks. And of course, evidence does not include any questions posed. And that goes to some of the questions you submitted. You may be thinking, hey, I asked a question and it was never answered. What should I make of that? Answer? Nothing. Questions aren't evidence. So if your question wasn't asked, it was not a legally appropriate question in this case. Doesn't make it a bad question, just legally inappropriate. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, such as an eyewitness. I saw the car run the red light and hit the pedestrian. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. I heard what sounded like squealing wheels and someone say, ouch. Sounds like someone got hit by a car, but I didn't see it. I can give you these other facts. Squealing wheels, someone said, ouch. There is no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence that you've seen and heard in this case, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. When parties stipulate, as they have in this case, you should accept that stipulation as evidence without the necessity of further proof. Whoops, skipped one. You will be determining the credibility or believability of the witnesses who appeared before you. In deciding this, you may consider all the evidence, the witnesses' manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony before you to statements that he or she made before trial. You must decide whether there's a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from expert witnesses during this trial. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. The testimony of an expert, like that of all witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find the witness's testimony to be sufficient. A defendant who has no burden to prove anything is not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. A statement that the defendant allegedly made while in custody has been admitted. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of his constitutional rights. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for that purpose. I'm about to get into the 12 allegations in the indictment, alleged crimes. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime that the state must prove beyond a reasonable doubt. Criminal intent is not the intent to violate the law, but is simply the intent to do the thing that is illegal. Criminal intent may be inferred from the evidence, as well as when it is the natural and necessary consequence of an act. You may not find a defendant who was merely present at the scene of a crime at the time it occurred guilty of the crime, unless the evidence shows beyond a reasonable doubt that the defendant committed the crime, helped others to do so, or otherwise participated in the criminal activity. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Murder. For murder, the state must prove that the defendant, number one, caused the death of another person, two, unlawfully, and three, with malice aforethought. The killing must have been done with malice for it to be murder. Malice, as the term is used here, does not necessarily mean ill will or hatred. Rather, it is simply the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be significant provocation and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that is, that unlawful intent, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice or intent to arise in the defendant's mind. This malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act that killed, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not an element of the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the killing. Felony murder. There's several counts of felony murder in this indictment. For felony murder, the state must prove that the defendant, number one, caused the death of another person, two, by committing a felony. The state does not have to show that the defendant acted with malice, that is, that unlawful intent to kill, in order to prove felony murder. Aggravated assault, false imprisonment, possession of a firearm by a convicted felon, and the use of a firearm by a convicted felon during the commission of a felony are all felonies. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing aggravated assault or false imprisonment or possession of a firearm by a convicted felon or by the use of a firearm by a convicted felon during the commission of a felony, regardless of whether the defendant intended the death to occur. There must, however, be some causal connection between the felony, aggravated assault, false imprisonment, etc., and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after that other felony was committed. That felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with a deadly weapon. And for your purposes, a firearm is a deadly weapon. False imprisonment. For false imprisonment, the state must prove that the defendant, 1, intentionally detained another person, 2, without legal authority, and 3, did so in violation of the person's liberty. Possession of a firearm during commission of a felony, which is count 8 in the indictment. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. It's one of the few statutes that's defined by its title. Murder, felony murder, aggravated assault, and false imprisonment are all felonies, and firearm includes any handgun. Count 9 is possession of a firearm by a convicted felon. And for that crime, possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. And again, firearm includes any handgun. Count 10 is use of a firearm by a convicted felon during the commission of a felony. And for that offense, as it's charged in count 10, the state must prove that the defendant, number 1, had on his person or within arm's reach a firearm during the commission of a felony against another person after having been convicted of a qualifying felony. That's where the stipulation kicks in. Firearm includes any handgun. Murder, felony murder, and aggravated assault are all felonies against another person. 2 more crimes for which you need to learn the elements. Concealing the death of another. For concealing the death of another, the state must prove that the defendant, number 1, concealed the death of another person. 2, in a manner that hindered the discovery of whether that person was unlawfully killed. And as for tampering with evidence, the state must prove that the defendant, 1, knowingly destroyed or concealed physical evidence, 2, with the intent to prevent his apprehension or obstruct his prosecution. Ladies and gentlemen, you should consider each count in this indictment individually. A defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence together with this charge, which is almost done, you should unanimously, all of you, find beyond a reasonable doubt that the defendant did commit here in Fulton County any of the crimes alleged in this indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would check that option on the verdict form for that offense. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit. In which event the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, signed by your foreperson, and dated. Here's a sample of what the verdict form is going to look like. Count 1, murder. We find the defendant You're going to check guilty or not guilty, whatever the group as a whole unanimously decides. By no ruling or comment that I have made during the course of this trial have I intended to express any opinion about the credibility of the witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws I have given you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that another juror is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are, as I've now told you many times, the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign the verdict form to which you all freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with everyone and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor, continuing, may you conduct any outside research. You have all the evidence in this case, and it would be improper to supplement it with any outside information. To assist you in complying with this particular instruction, Deputy Gordon will be keeping your electronic devices as long as you are deliberating. I promise you get them back. Smartwatch, phone, tablet, laptop, mainframe, whatever you have back there, we're taking. It's going to make little beeps and boops back in my chambers. When we're done for the day, they go back to you, but they're not there in the jury room. And going forward, should you need to communicate with me for any reason, it needs to be in writing. And you've mastered it. You write it down on one of your note cards or something from your notepad. When I get your question or note or concern or whatever it is, I will confer with the lawyers and Mr. Dennis, and then I'll share with you whatever response I am allowed by law to give. And that allowed by law is an important phrase. You may have a great question and my answer is going to be, you got to figure that one out yourself because I'm not allowed to answer that. A classic example would be, hey, we don't remember about X. And I'm going to say you're going to have to rely on your collective recollection. You're not going to get transcripts of testimony that happened during the course of the trial. That's why you took notes. And you guys will recreate what happened through your discussions. But if there is an answer I can give you, I will do my best to give you that in a comprehensible way. That concludes my instructions to you. So before you retire to the jury room, I need Mr. Minor and Mr. Okafor, you should stay here. The other 12 of you should go to the jury room. Please don't start your deliberations. You can figure out who your foreperson is and get in deliberating position, but wait until you get the evidence. You'll have the indictment, you'll have the verdict form, you'll have the jury charge, you'll have that stipulation. When all that gets there, and Deputy Gordon will be bringing it, you'll be free to deliberate. One more thing, this thumb drive has on it the Exxon video that was admitted and the 2 911 calls. If you want to watch or listen to those, just let Deputy Gordon know. There's a screen in there. There's a little computer in the back. We can fire it up and it's not connected to the internet. All you'd be able to do is watch and listen, listen and watch. But you can do so to your heart's content if you want to watch those things. If there's something that you remember from evidence that didn't go back with you, that would be a question, hey, we'd like to watch or hear X again. And that's something that has to happen out here. We bring the 12 of you out here and we would play or watch or whatever it is that wasn't sent back with you. Okay? So this thumb drive, that's what's on this thumb drive. That'll go back with you all. With that, the 2 of you whose name I mentioned, stay here. The rest of you, please retire to the jury room.
All right,
Gentlemen, you are our alternates. Had we lost a juror yesterday or the day before, one of you unknowingly would have moved into a deliberating juror position. You remain our alternates. It could come to pass that we need to excuse one or two of the deliberating jurors, in which case deliberations restart and you come in and we start from scratch. I need you to stay here today as long as the jury's deliberating. You will be able to be in that jury room over there that says shelter location on it. You get to keep your electronic devices. Just don't use them to research the case, communicate with others about the case, but you can sleep, work, whatever you want to do. And you two can talk, just don't talk about the case. You are sort of on hold, on standby in case we need to excuse a juror. At the end of today, if the jury doesn't reach a verdict today, we can talk about whether you come back tomorrow or if you can be close enough that if we need you, it takes you less than about a half hour to get here. So just be thinking about that. And if home or work has you within a 25-minute arrival time, then you won't need to come back tomorrow, but you'll need to have that phone on you in case we need to reach you. But we'll talk about that at the end of the day. Okay? Any questions about that? Nope. Okay. You should get your stuff, say bye to your friends, and Deputy Gordon will get you in the other jury room. Mr. Bass, I think I asked you this, but let's get it on the record. Mr. Abate handed me a redacted indictment that simply says convicted of a felony, qualifying felony. There's actually not even reference to the case number or the jurisdiction in the redacted version of the indictment. You were okay with that? You have seen it. Okay, if you will come forward, I need you and your client to sign this one in or not guilty plea. Both will be part of the record, the unredacted version, but we need to get that signed, and then Mr. Abate or Mr. Rao can sign it. And please date it the 21st, not today. 21st is when you entered the plea of not guilty. Mr. Rao. Whoop. Hold that thought. I didn't say take snacks. I just said get your stuff. You look at counts 8, 9, and 10.
So the record clears, Your Honor. I took the county as well as the case number out, just still with me or the jury charge.
That's fine. I didn't, Mr. Bass said he didn't have an issue with it, so.
Sorry, I was saying, the judge had referenced that I took out the county as well as the case number in 9 and 10. I just did it so that would mirror the jury charge. Correct. The judge did.
So they took out the description of that. And then somebody's not. Something.
That changes legally.
You should see, 40%. They're like 40% capacity. It's crazy.
Big jurisdictions there.
3 people working. 3 people working different. 1 person working 3 courts.
Good? All right. What about the physical evidence that goes back? Did the two sides confer?
Yes, I think we agreed after all the parties went through it, that the only one that did go back was stated to want the actual certified picture.
Okay. Let me then give Deputy Gordon stipulation, indictment, jury charge. Just need the verdict form and the thumb drive. Verdict, thumb drive. All right. Okay. We're good. Okay. I need one phone number from both sides that I can call that will get a lawyer from both sides back here whenever there is a jury question. You're welcome to stay in the courtroom, but if you want to be out and about, you just need to be reachable.
They said they want to start tomorrow.
Okay. No, we can. No, let's keep it all together. It all stays together. All right. Mr. Abate, anything you want to get on the record before I bring the 12 jurors in to tell them to be back tomorrow? No. Mr. Bass? No. Okay, let's bring the jury in, please.
All right, so the jurors. All jurors present and accounted for.
Thank you. Deputy Gordon shared with me that rather than get started now and not work for super bit, you're gonna, the vote is to come back tomorrow morning. Is that correct? Okay. As I mentioned, the clock is in your hands now. We need to agree on when you're going to be back because you may not deliberate. In fact, you won't get the evidence or any of that stuff until all 12 of you, down to 12 now, are here. Did you agree on a time that you'd all be here? And what's that time? 9. Okay, 9 it is. You guys are gonna, I think, police it better since 11 of you wait for the 12th to be able to do something if you're not here. We'll be here. Buzz in early if you want to get here early. That's fine if that's how your travels work. And you can start your deliberations then. As with previous nights, no outside research. Don't consult with people to say, I'm about to start deliberating. Do you have thoughts? How would you decide this case? That is just so much not what other people need to be telling you. That's what you'll be talking about with the 11 others in the room. So please, no outside research, remain discreet about the case. And we will see you all as close to 9 as you can make it. You'll report straight to the jury room. I won't bring you out here. I'll just know when Deputy Gordon tells me all 12 are there. I'll make a notation. He'll get you the evidence in exchange for your electronic devices. And we'll go from there. Logistical questions? None? Have a good Thursday evening. Thank you.
All right, let's do it.
Gentlemen, you did a great job as alternates. Can you take a seat in the jury box for a quick second? So your former colleagues decided they just want to start fresh in the morning, so no deliberations today. We're at that point now where I need to find out whether you want to be here at 9 tomorrow. That's when they're coming back. Or if you would either at work or at home be close enough that if we called you, you could be here in about a half hour. Mr. Okafor, what's you'll come on in? Okay, please try to be here by 9. Know that you'll have straight downtime. And so if you want to bring work, I guess given your line of work, you'd be bringing people. Don't bring people, so don't do that. But anything you want to do, as long as it's not researching the case or talking about the case, you're free to do. You'll be in, will we be able to use that jury room? You'll be in a jury room. We'll get you a space. The two of you will be in the same space, assuming Mr. Minor's coming in. What is your, not your preference, but what works best? Okay, then you'll be here at 9 as well. Same offer, bring work, whatever you want to do. Because unless you're pressed into duty as a deliberating juror, it's downtime. It's still jury service. Your letter will cover all those days. You're just waiting to see what happens in there. Okay? Any questions about that? Usual restrictions, no outside research, don't talk with people about the case. I don't even tell them you're an alternate because that may prompt someone to say, oh, that means it's this kind of case or that. It actually just means you had a higher number in the jury pool.
So we, for lack of better terms, in timeout until they were needed upon, or when they come to a decision, do we get brought back in to at least hear the decision?
It's one of the two. Either you are pressed into service or if there's a verdict or a hung jury, you will be notified of that. You might not physically be in, if it's a verdict, you might not physically be in the room while the verdict is being received because there's some procedural things that maybe you're not in the mix of because you're not a juror. But when we excuse everyone, all 14 go back to the jury room. I thank you for your service, get the letters. And so you will not be in the dark about what happened. You will be told exactly what happened. In fact, you'll be there for that discussion that I have with the jurors who deliberated. Okay? Appreciate your understanding. See you at 9 tomorrow.
I'll try not to be here at 7.
He was doing that guy.
He must have a traffic situation where he's from. Yeah. Yeah. He's Roswell, so it could be pretty far north too. Mr. Rao, anything from the state before we wrap up for the day?
Yeah.
Okay. If one of you could be here at 9 or at least, I have a number for you. Will that work for that side? Okay. Mr. Bass, if you could just leave me with a phone number. I know you'll be here at 9 anyway. If you don't plan on leaving the courtroom, then.
It's classified.
Okay, well, unclassify it, declassify it for Deputy Gordon at least.
Make it easy for you. Bam.
All right, thanks, everyone.
I will see y'all tomorrow. And I still can do it, y'all.